with Fanny, playing dirty tricks in the courtroom. She always picks, bending the rules. She know it, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey, folks, and welcome to day 130 in this clock of a trial. Yeah, I know I should have been on earlier, but work got in the way, and now I'm on. It is 2 p.m. So I've been in phone conferences all afternoon, my time. So I have no idea what's been going on today. No idea. Well, until I heard that the QC situation, Lil D as in Zachary Lil D, apparently, and this is, I told you guys that Prosecutor Love doesn't have a soul. I told you. There's nothing inside. They put QC in jail Friday. During the weekend, the family got a fundraiser going. They got him representation, and this morning his lawyer pleaded to the court, you have to let him go. You have to let him out of jail. This is not okay. And then he was told, oh, he's back in hospital. Nobody told his lawyer. Nobody told his family that he has been in jail all weekend, and apparently Monday morning he was driven to hospital. That's all the information I have. I have nothing else at the moment on how she is. But again, if this doesn't tell you that Miss Love is an evil human being, I don't know what else to tell you. QZ has a life-threatening illness, if not treated, and they put him in jail over the weekend. They took him more or less on his way out from hospital. However, they found out he was being released from hospital and put him in jail over the weekend. And remembering what they did to Woody, depriving him of food, giving him dirty water, if this was given to QZ, yeah, it's bar cards needs to be taken away for this. Yeah, sickle cell anemia, and if not treated, that could kill you. It's a very high possibility or risk, if untreated, that you pass away from it. Miss Love knew this, and she did it anyway. Hey, microphone. I have it in front of me now. Hopefully this will make sound a bit better. So, yeah, I wish I had more information for you guys, but I haven't seen anything from the family yet on social media or anyone. Gwendolyn says, oh, sorry. There, Starfish and Coffee is back in Grady Hospital, and the sister wrote a letter to the judge. His lawyer appeared in court before Whitaker before lunch. Okay. So we will get there eventually. But yeah, it's infuriating. I mean, I hope he will be okay, but chances are he's not. Putting in jail over the weekend with that amount of stress, because once you're released from hospital after a blood transfusion to more or less save your life, you have restrictions on you what you can and cannot do. One of the things that is a can't, I would assume, is being put in jail. So yeah, whatever treatment he underwent last week might have been undone by Miss Love. All right. Hopefully I can give you more information as this moves along. But let's go to the trial. I will play this 1.25 so we get caught up eventually. And let's go.
The state owes me hard copies of correspondence to do an in-camera review. Is that ready?
It's being finalized, and it will be brought over after it is finalized. We had a number of things that we were going to bring in for today.
Okay, so that was supposed to be to me first thing this morning because I need to actually do the in-camera reviews. When is it going to be? Obviously, I'm not going to be looking at it before lunch.
Oh, to nobody's surprise, Miss Love isn't ready. She had until Monday morning to get this done, and she has not got done. To nobody's surprise. At what point, Your Honor, is enough enough? At what point?
Lunchtime, but
I think we can have it all to you by lunchtime, and my understanding is that we want to begin with the witnesses, and that the things that were told to be available today would be available today.
I specifically said first thing this morning. So I need it by the time we break for lunch because I'm planning to start looking at it at lunch.
Yes, you are.
Okay, what else are you going to have to me?
The court told me to have the four corners case law.
Okay.
As well as we have the response to the brief that Ms. Bossy presented regarding the transaction. I believe that we were also working on narrowing down the wiretap.
Okay.
Calls at the court.
All right, anytime today is fine for the rest of them, but I specifically said first thing for the in camera. So I need that by the time we break noon, basically. Mr. Steele, I got your, I guess, motions in limine on some of the evidence that y'all reviewed on Friday. And I don't know whether y'all try to narrow it down or not. And that's what we need to litigate still. Is that what that is?
That's what and when I say we, it's
The defense.
yes,
Yeah.
Your Honor. We believe that needs to be excluded.
Okay.
That's correct. If the state, upon looking at that, says they agree with it, then obviously we don't have to take the court's time. But that we tried to, go through
Okay,
it,
but it hasn't been
vetted.
presented to the state for potential agreement. Okay, so I'll let y'all do that. And then next time we have an on-jury day, whatever is left, we'll take up. Good morning. All right, I had another matter that we were supposed to be starting at 8:45. I'm not sure why we didn't get started until 9. But I'm not going to take the jury's time right now. So just when we break for lunch, I want y'all to come up and I'll apprise everybody of something that I don't think between here and lunch, it's going to matter if y'all don't know. Give me just a second.
All right. What was causing the delay? If they were supposed to start at 8:45, what caused the delay? Was it the QZ thing? And if it was, why didn't they tell the court? Okay. Let's see who the state's witnesses. Dog in the house. They have changed around a bit with the defendants.
Thank you. Ladies and gentlemen, good to see y'all all back again. I hope y'all had a pleasant weekend. Miss Love, y'all can call your next witness, please.
Good morning, Your Honor. The state now calls Officer Adrian Pitts to the stand.
I can hear you, but I don't know if it's through the mic or
Okay.
not. You can try the other one.
Sure thing, Your Honor. I will.
Raise your right hand. You swear firm testimony you give the truth, whole truth, nothing but the truth.
I did.
Absolutely. State and spell your name, first and last name for the court.
Officer Adrian Pitts, Adrian. Pitts, Pitts.
Good morning. Can you hear me quite all right?
Yeah.
All right. I am going to position this like so I can have the use of my hands. Officer, Mr. Pitts, are you employed?
Yes,
Where are you employed?
the Atlanta Police Department,
And how long have you been employed with the Atlanta Police Department?
approaching 14 years.
And what is your title?
Police officer,
Have you received any special distinctions as a police officer during your 14 years?
tactical field operator.
What do you do in that capacity?
It's just SWAT, barricade gunman, active shooter situation, stuff like that.
Is that also known as TFO for short?
Yes,
And what are your duties and responsibilities as a tactical field officer with the Atlanta Police Department?
active shooters, barricade gunman, assistant SWAT, barricade gunman.
And if you would come just a little bit closer to the mic.
The problem is the mic won't move, so we're gonna try to move that at lunch.
And this is both of them.
I'm gonna give you this mic. Because we've got all right, so that you can face that way.
Okay.
All right. Can you project and see if it works?
Test.
There we go. All right. Are you post-certified, Officer Pitts?
Yes,
And have you been post-certified during the entire duration of your employment with the Atlanta Police Department?
yes,
And were you post-certified on April 28th, 2015?
yes.
All right. I want to turn your attention to the date of Tuesday, April 28th, 2015.
And
Recall working that day.
Yes,
and he has impeccable memory of April 28th, 2015, because I assume they have had him study it for, yeah, and police officer for 14 years. Yeah, that he didn't climb the ladder. Supposedly it's under 14 years. He didn't get far up the ladder. Yeah, but here's the deal. Some people like being a cop on the streets.
Okay. What, if anything, do you recall about working that day?
about 4:06 hours that morning, I was dispatched to a person shot.
All right. So now when you say 406 hours, what do you mean?
4:06 in the morning.
Okay. All right.
Impeccable memory. Even at that, it was 4:06.
Shot call. Did I understand that correctly?
That's correct.
Okay. Were you alone or were you accompanied by a partner?
I believe initially I arrived alone, but other units did arrive shortly after I got there.
And when you were dispatched to this call, how did the call come through?
Person shot at 1428 Dale Avenue.
Okay, that was a poor question on my part. Let me ask a different way. Was it over the radio? Was it a phone call? How did you get dispatched?
I was dispatched over the radio.
And when you were dispatched to that person shot call over the radio was a location given.
Yes,
What was that address?
1428 Adele Avenue, Northwest.
All right. And were you wearing a body cam that day?
No,
Okay, why not?
No body cam, but I don't think they had body cameras back then. Not entirely sure. Manders 13. Is this memory or recitation of his police report? This is recitation of his police report. He had this memorialized because there's no way you can be this detailed. No way you can be this detailed without having had it in front of you the entire weekend just to make sure you remember it all.
body cams had not been issued at that point.
You just mentioned the address of 1428 Adele Avenue Southwest. In what county is that address located?
Fulton County.
Are you familiar with that community that address is situated in?
Yes.
And what can you tell the juror, ladies and gentlemen of the jury, about that particular community?
It's a lot of single family homes, older Black families own their properties for years and decades.
Okay. Are you acquainted with that particular area?
Yes.
All right. How are you acquainted with that particular area?
Patrol over there. I was assigned to the beat that the shooting took place on. I'm very familiar.
Okay. What zone is that in for Atlanta Police Department purposes?
Zone 1.
Okay. And what beat is that located in?
Beat 104.
Now, can you distinguish for the ladies and gentlemen of the jury what a zone is and then a beat?
So the city is broken up into 6 zones. Every zone has 2 sectors. Each sector has 7 beats, and that's just the area of responsibility that each individual who's assigned to the beat handles.
You can do that. I wasn't interrupted.
That's it.
Okay. All right. With respect to a beat, the particular beat that you were responding to on the day of April 28, 2015, how long had you worked that beat?
At that point, maybe about 2 or 3 years, but I've been inside that area for a very long time.
The address of 1428 Adele Avenue.
I see. I'm seeing a thing on by my the channel friend, Mr. Sal, who says they arrested him to testify, and he isn't even prepared for the witness stand. They had no interest in calling QZ to the stand today, and they still arrested him Friday, kept him in jail over the weekend, and put him back in hospital Monday morning. And they have all these witnesses lined up. That seemed planned. They had no intention of calling QZ as a witness today. None, in my opinion. Again, if this doesn't tell you the prosecution is evil, I don't know what to tell you.
Southwest. What, if anything, is situated there?
Residents,
Okay. Is it an apartment complex or a single family home?
single family homes.
All right. And can you describe for the ladies and gentlemen of the jury what, if anything, you saw upon your arrival to that location on April 28, 2015?
Upon my arrival, I saw shell casings in the street, driveway, property damage. Front of the house had been shot up. Vehicles in the driveway had been shot. I think one vehicle in the street also was damaged by gunfire.
All right. Where were these shell casings? Excuse me. Where were these shell casings that you just mentioned located in your life?
The shell casings were
Just a brief indulgence, John. All right, I think we got it.
so the
No, we didn't. I project as best as I can.
If somebody over at the far side of the room cannot hear you, I'll just let me know.
Okay. All right. Been told to be pretty loud around. All right. So you can continue with your answer. If you need to re-ask the question, I can.
please.
Okay. All right. You described just a few moments ago that you saw several things. I believe the last question I posed to you was, where were these shell casings that you spoke of earlier?
The shell casings were in the street directly in front of the home
Okay.
and inside the driveway of the residence.
Right. When you arrived to the location, was it nighttime or daytime?
It was early morning. Sun was not up. It was night.
What was the weather conditions on that day?
Clear.
Okay. Was there anyone outside preliminarily when you arrived to that location?
Outside in the street, no, not that I remember.
What was the atmosphere like? Was there? Can you describe the atmosphere, if you will, for the jury?
When I arrived, it was very still. You could tell that something had happened. Approached the house. If I remember correctly, the front door was open, but it's like a steel security gate was closed, and there's a gentleman standing at the steel security gate.
Before I move to what you just said, I want to go back to something you said earlier. You also indicated that there were damage to vehicles that you saw preliminarily when you arrived. Do you recall saying that?
Yes.
How many vehicles do you recall at this time being affected by the defects?
3.
Okay. Do you recall the make and models of said vehicles?
Yes.
Okay. Can you describe for the ladies and gentlemen of the jury what those vehicles were, make and model?
It was a red Infiniti. I believe that was in the driveway. It was a blue Dodge Charger. I believe that was also in the driveway.
Red
A
Infiniti?
blue Chrysler Pacifica parked on the street.
There is no way on God's green earth you can be this specific without having memorialized everything in your police report. This is just stupid. I mean, not even the best of the police officers who have been on the stand has been this detailed, but this Yahoo, oh, this color, this car, it stood there in the driveway. It's the this must be obvious. Even I mean, this is so obvious. He is so coached. It's ridiculous.
Was the Chrysler in the street?
I believe it was on the street.
Okay. Are you sure about that?
I'm not 100% sure. 10 years ago.
Is there anything that would help you refresh your recollection at this point?
Oh, his memory was flawed. So the prosecution had to, are you sure it was on the street? Did you memorialize it wrong? Can I refresh your recollection? Oh, jeez.
I can go to my report if we have a moment.
Yes, if you would just give me a brief moment. Your Honor, I am going to approach the defense with your permission, of course. All right. With a copy of
When I lived in Gothenburg 25 years ago, I used to sell knife-proof vests to security personnel working the bars. And I did quite good. Then everybody started buying directly from my...
Look back up at me and with the 10.
Then everybody started buying directly from the people I bought from. So that was an interesting year of business that ended abruptly when everybody looked at the label and said, we can buy this directly. Yeah, the state is apparently all about the April 28th shooting. And I believe the people, if I remember correctly, if I'm not, correct me, but the people allegedly who did this did their time. None of them are the defendants. None.
Memory been refreshed.
Yes.
All right. Can you now respond to the question that was posed?
Give me to 15 one more time.
Sure.
Yeah.
Where was the Dodge? Where was the blue Chrysler Pacifica?
I believe the Chrysler Pacifica was in the driveway.
Okay. All right. Okay. Now, can you describe for the ladies and gentlemen of the jury the tag numbers associated with said vehicles?
So I could go to the report.
Sure thing, yes, sir.
Okay. So the Chrysler Pacifica was a Georgia plate, Paul Charlie Sam 5023. The Dodge Charger was a Georgia plate, Paul Victor Yankee 5663.
Okay.
Red Infinity, it's going to be Paul Whiskey King 8190. It's PWK 8190.
Okay, all right. Now, I would like to ask you with respect to each of those vehicles, do you recall by any chance, for the ladies and the gentlemen of the jury, where the defects, bullet defects to those vehicles were located around or about?
Yes, the Red Infinity had defects and damage to the front hood and the front windshield. The Blue Dodge Charger had defects to the front hood, front windshield, and the Blue Chrysler Pacifica had defects to the driver side rear panel area.
Correct. On that early morning of Tuesday, April 28, 2015, were you at all able to speak with the owners of said vehicles?
No, I don't remember.
Okay, were you able to speak with them ever after you finished with this particular location responding to it?
No.
Okay. Did you attempt to, or did anyone from your department or precinct or zone try?
I'm not sure. I'm pretty sure I did not.
You described earlier that there was property damage to the home located at 1428 Adele Avenue Southwest. Do you remember that?
Yes.
Okay. Was there any damage to your recollection to any of the other homes located on Adele Avenue?
No, all the damage was focused on the house, and I guess the vehicles were damaged as a result of the house being shot up.
And when you say the house, is it my understanding correct that you're speaking of the 1428 Adele Avenue Southwest address?
Yes.
All right. Earlier, you provided a brief description about what it looked like, that being the house that you just described. You stated that there was a gate. Do you recall that?
Yes.
Okay. You remember the color of that gate?
White.
Okay. And when you say a gate, are you referencing a door that appears to be as such, or a physical gate that prevents one from coming into the premises of the property?
It's like a metal security gate that goes in front of the front door.
Hold on, I'm scouring the internet for information, and apparently Woody has a warrant on something that is unrelated to this case. Okay. Anybody knows anything more? Because first of all, is it correct? Second, for what? Okay, Kayla said he doesn't. Okay, then it's just a rumor. Thank you, Samantha Yo. Thank you. Welcome to my show, where I ignite the rumor and debunk the rumor immediately. Thank you, guys. Thank you.
It's common on a lot of houses in the area.
Do you reference a gate in your report?
Yes.
Okay, and is that what you had in mind when you wrote that report?
Yes.
Okay.
Unclear at the moment. Thank you.
What has been pre-marked as State's Exhibit. State's Exhibit 8, Captain, Your Honor. And I am showing the defense that is, what has been pre-marked as State's 8, Captain.
Okay, Samantha Yo, it was fair to assume he called her on her live this morning, and it sounded like that's what he's. Oh, oh, live. But he said it was about his four-wheeler and a traffic violation. Yeah, most four-wheelers aren't road worthy, so even I know that because I watch other shows. other shows, as in how to live off grid. I love those shows. I love those shows. So I learned it from there that in most states you can't drive a four-wheeler on the road if that is what he did. I have a four-wheeler, but I bought it at an auction, just looking at the pictures, and when I got it here, it was a kid's four-wheeler. I looked so stupid trying to drive that thing. But okay, anyway, back to trial.
Come behind you, collect.
I understand.
Let me rephrase. Is that something that you would normally collect, microparticles?
No,
Okay. Does it have any value outside of you being able to detect whether the bullet defects are old or new?
no.
Okay. All right. I want to turn your attention to the moment where
Yeah,
you said you were
Donkey
out
Kong
to the
on
location.
Mario Kart.
Did you ever get out of your vehicle?
Yes,
And how were you dressed on that day?
in uniform,
And were you in a marked or unmarked police car?
marked police car.
And did you ever walk up to the home of 1428 Adele Avenue Southwest?
Yes.
And what, if anything, did you do or say during that time?
I met a gentleman, black male, medium brown skin tone. He was at the door wearing a Fam America brown sweatshirt. I asked him if he had been injured. He said that he had not.
I'm going to object to the hearsay.
Sustained.
Your Honor, if I may respond. This is, of course, an active investigation, and this is the effect on the listener. He informs what will come next.
Just move on to your next question.
Sure thing, Your Honor. All right, I'll move on to the next question before you.
Oh, this prosecutor, since he wasn't allowed to answer, he gave the answer anyways in his objection. Now, the defense does that, but we expect them to. The prosecution is supposed to have ethical obligations to not do it. But swings and roundabouts.
This individual that you described, you just provided a description. Was he tall or short?
I can't remember.
Okay. Do you recall if he was taller than you?
I don't think he was there.
And you described the shirt he was wearing that you said had Fam America on it somewhere. Is that correct?
That's correct.
And when you saw that shirt, did he have any value to you when you saw that name?
Fam America at the time was a prominent gang in the area.
I'm going to object as to improper foundation and move to strike.
Can you lay the foundation?
Sure. I can ask a few preliminary questions, John. Sure. What training or experience do you have with gangs in that area?
Plenty of experience. Sometimes that we get information from investigators to keep an eye out for this type of clothing or this type of.
Sometimes we get information to have a look out for. That's not foundational. That is still hearsay.
Coloring or these type of tattoos that would indicate gang affiliation.
Okay, and was that your first time seeing?
Excuse me, I'm going to object that testimony again and ask it to be struck. It violates our ability, the confrontation clause, our ability to question where this information is coming from. It is hearsay. I'd ask that answer be struck.
Overruled.
Okay.
Yeah.
You can continue with your answer if you had any.
That was it.
Okay, all right. And with that particular background in mind, was this incident to which you responded the first such time that you had ever seen such indicators of clothing as you described?
Yes, I believe so.
Okay, all right. And your experience, based on what you had learned prior to that moment in your training, did that language on that sweatshirt have any value to you as a law enforcement officer with such training?
This is
Your
so
Honor, I'll renew my
stupid.
objection. Indicate there's not proper foundation that's been laid.
I'm sustained at this point.
Okay. All right.
Okay, I'm starting to realize why this cop haven't climbed the promotional ladder. He's parroting his whatever they put in front of him. So he memorized it and he is telling it back. Almost like a parrot. but he doesn't seem to understand. Okay, why are you asking me this question? You haven't told me what to answer.
Have you ever had formal gang training?
No.
Okay, but have you ever had interactions with gangs?
Yes.
And have you come to learn prior to April 28, 2015? Let me rephrase this question. What identifiers, to your knowledge at that time, in April 28, 2015, did the gang, as you described, Fan America have?
Sometimes they wore clothing that had their
Sustained.
Time to move along.
I'm gonna move on to another question. At that time that you saw this individual with the shirt and indicated that you described, language, Fan America,
yes.
what, if anything, did you do after that?
I went to the home and looked for an injured party.
Okay, when you say you went to the home, are you saying you went in the home?
I went inside the home and looked for an
And
injured party.
when you went inside of the home, what, if anything, did you see or do?
I spoke with the person who was struck by gunfire. If I may refresh my memory.
Sure.
The victim, Denise Renee Bell.
I want to ask you a little bit before we transition to what you did in the home. I do remember what you said last.
Yes.
Orienting you back to what you said when you met the individual, the male at the
Yes.
front door. Can you describe around or about his age?
He looked to be in his mid to upper 20s.
Okay. What was his demeanor?
He was calm.
And when you entered the home, did you actually, in fact, see an injured party?
Yes.
And where about in the home do you recall her being?
She was in a rear room of the residence.
Did you ever get a name for her?
Yes. Her name was Denise Renee Bell.
Were you ever given a name for the male that met you at the front gated door that you described earlier?
No.
Did you ever ask?
No.
Did he remain the entire time that you were completing the course of your investigation?
No.
Okay. Where do you recall where he may have gone?
No. He's gone.
Okay. Do you recall at what point he left the property?
While I was speaking with the victim, he left. I asked where he went. Nobody knew.
I'm going to object to the hearsay.
All
The
right.
answers, nobody knew anyway. so. Sustained.
Your Honor, may I do so?
Move on.
Do you recall what relationship, if any, this unknown black male in this Fan America shirt had with the victim in the home?
Your Honor, to the extent it calls for hearsay, I would object.
I'm sorry, but I couldn't hear what you said.
To the extent that that response calls for a hearsay, I would object.
I'm sorry, re-ask your question. I was focused on what you said and I've lost what the question was.
No problem, Your Honor. All right. Do you recall what relationship, if any, the unknown black male in the Fan America shirt had with the victim?
Okay, sustained.
Do you what? Do you know the relationship between the unknown? How is that even remotely close to a question you can be allowed to ask? Judge, pay attention.
To the hearsay objection.
Do you know if he resided at that location?
No.
How familiar are you with Club Crucial?
Fairly familiar.
All right. And how are you familiar with Club Crucial?
Club Crucial is a nightclub that is in the zone. It's on Bankhead, down at Lee Hollow Parkway.
When you say the zone, what zone are you referencing?
Zone 1.
And being that it was in the zone, is it fair to say that you would pass by there?
Yes.
And how often would you be in that area, specifically where Club Crucial is located?
Typically, we would patrol and post up outside the club, opposite side of the street when it's in operation.
Why would you post up across the street from Club Crucial?
Sometimes it does attract a a rowdy crowd.
And how often would you post up?
Every night was open.
Okay, and how often, to your knowledge, would it be open?
Mondays, Fridays, Saturdays, and maybe Sundays.
And to your knowledge, was Tuesday, April 28th, 2015, the early morning hours from when that club would have been letting out?
Yes,
And were you doing direct control over there prior to responding to 1428 Adele Avenue Southwest?
I can't remember, but I'm sure that I was.
And would you do it alone?
No,
And around or about how many law enforcement officers would be a part of that direct control team?
maybe about 2 or 3 units,
When you say units, are you talking about vehicles or persons?
vehicles and persons. So 2 or 3 officers.
And do you know the hours, if you recall roughly about the hours of operation, not the days, but the hours of operation for Club Crucial?
I recall that it closes at about 3.
Based on your dispatch call, about how long after Club Crucial, excuse me, let me rephrase it, I got tongue tied. Based on your dispatch call, about how long after Club Crucial formally closed did this gunshots fired call come in?
A little more than an hour.
About how far, to your knowledge, is Club Crucial from 1428 Adele Avenue Southwest?
Yeah, Dave.
1428
More
Adele
shenanigans.
Avenue is probably a few miles south of Crucial, maybe about 3 or 4.
Okay. Are you familiar with an Officer Clinton Hayes?
Yes,
All right. And are you familiar with him having patrolled in that particular zone?
yes.
And do you know if he would have been patrolling in that zone around or about the time you were assigned to it?
If we were both working that night, then he probably was, yes.
And would he have also been one who is, I'll rephrase the question. Actually, we'll just start the question. Do you know if he was doing directed patrol on that particular day?
I can't remember.
To your knowledge, what was the busiest night for Club Crucial?
Objection, relevance.
Very relevant. Huh?
Overruled.
Mondays and I believe Saturdays.
I am now showing you what has been previously admitted as states exhibits 2 Tango through 6 Tango, and they will be published on the screen. Just a brief indulgence, Your Honor, while we get that technology.
No problem.
Why are they keeping this guy on the stand? I mean, all he had to do is, what did you do? This. All right. Cross-examination, blah, 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 blah. Done.
It's now
Off you F.
Exhibit 2 Tangos. Right. Yes. And these, Your Honor, for the court's edification, they were admitted through Officer Clinton Hayes. That's right. Showing you now what has been admitted previously as State's Exhibit 2 Tango, and you're now seeing it on the screen. What are we looking at here?
That's the front face of Crucial.
And is this how you remember it to have looked in April of 2015?
Yes.
Okay, and is Club Crucial still open and functioning by any chance?
Yes, it is, but I don't work at night anymore.
And does it still look like this, or has it changed to your knowledge?
The red stripe is no longer there, and they have a security gate in front of both driveways.
Right, and I am now transitioning your attention to State's Exhibit 3 Tango. All right, what are we looking at here at State's 3 Tango?
That's Crucial.
All right, do you see the red stripe that you saw in the last exhibit?
No.
Right. Do you see the security gates that you just talked about?
Yes.
And were those security gates there in 2015?
No.
You know around or about when those gates were placed there?
No, maybe last year or so.
Now showing you State's Exhibit 4 Tango. Where do you see the brown structures on that property?
Yes.
Were those brown structures there in 2015 to your recollection?
No.
Do you know around or about when those brown structures got there?
No.
Brown structures? these are wood sheds.
And is it, what are we looking at here?
That's Crucial from the parking lot.
Do you see any tire tread or marks on the ground on this exhibit? Or-
Yes.
All right. To your, based on your training experience, why would marks like that be on the ground?
Your Honor, that would call for speculation. I object.
Overruled.
And how is it even remotely relevant? It's a parking space thing. Everybody would do skid marks on that pavement. You could have an old lady in a 1998 Ford Focus, and she would drive up there and try to do a wheelie or a burnout. I mean, it's very inviting into what is going on here? How is this even remotely relevant?
Tire tread would be on the pavement because maybe somebody was driving in doing donuts.
Okay. Is that what that looks like to you, a donut?
Yes.
Is that some of the rowdy things that you described that would happen over there?
Yes.
I'm showing you the final state's exhibit that will be published from this category of state's exhibit 6 Tango. What are we looking at? What is the ladies and gentlemen of the jury? What are the ladies and gentlemen of the jury looking at here in state's exhibit 6 Tango?
That's still the parking lot of Crucial, but it's the facing east.
Okay. And what street is that running perpendicular to the building?
That's going to be Donnelly Hollowell Parkway.
Yeah, bad maintained pavement.
Crucial was about 2 miles or so from 1428 Adele. About how much time in terms of minutes would it take for you to get from Adele to Donnelly Hollowell Parkway, where Club Crucial is situated?
Maybe about 4 or 5 minutes.
And when you say 4 or 5 minutes, are you talking about driving or are you talking about walking?
Driving.
And to be sure, is Club Crucial and Adele Avenue in the same beat?
No.
Okay. Do you know what beat Club Crucial sits in?
Crucial.
Overruled.
Crucial is one of the 109 speed.
Right. I want to turn your attention back to the moment when you entered inside of the residence situated at 1428 Adele. Earlier, you stated that you saw the gunshot victim. Can you describe around or about her age to you at that time?
Mid-20s to late 20s.
Can you describe her demeanor?
She was excited. She was upset.
How was she positioned, if you will, inside of the home?
I can't really remember, but I believe she was, when I spoke with her, she was lying prone on her stomach.
Did you happen to get a date of birth for the victim when you were investigating this particular incident?
Yes.
All right. Would you have included that? Would you have included that in your report?
Yes.
And are you sure at the time that you made contact with her that she was in her mid to late 20s?
Let me refresh my recollection.
All right. I'll give you a few moments to refresh and then look back at the community concepts.
Do you really need this long to remind yourself, or are you just rereading to know, oh, this is what I'm supposed to answer?
I'm gonna ask you a different question. That I think,
If you had him remind himself, why are you moving on to a different question? What?
I want to circle back first.
Okay.
You are not even an hour in, and
Few
this
moments
is a
ago-
joke.
Did I hear you correctly when you said that she was excited?
Yes.
All right. When you approached her and saw where she was positioned, did you see where about on her body she was struck by a bullet?
The upper right buttocks.
And was she alive, alert, conscious?
Yes.
Is that yes to all three?
Yes,
she was alert,
bring
conscious,
Club
and breathing.
Crucial to the stand. The Club Crucial had red.
And
And a
was
green
she in
lawn.
need of, yeah,
Boo.
emergency medical services?
Yes.
And were emergency medical services called at that time?
Yes.
And do you recall who called?
I requested Grady EMS to come out and transport female.
Did you speak with Ms. Bell ever after that day?
No.
During your investigation of this matter, did you learn if there was anyone else did you see anyone else in the home while you were there?
Yes.
All right. About how many persons did you see and observe there?
From the start, when I got there was 6.
Okay, so do you recall the names of those persons?
Yes.
What are their names?
The other 4 individuals who were inside the residence, if I can go to my report.
Sure.
Taiwan Marquise Marsh, Cecilia Davis, Diamond Mills, Zaranisha Coakley.
About how old did these persons appear to you?
They all appeared to be in their 20s.
Late or early 20s?
Probably about mid-20s.
Do you know if they were residents of that particular home or passersby?
Calls for hearsay.
Sustained.
Did you, all right, what was their demeanor like when you encountered those 4 individuals you described?
They were all upset and excitable.
How were they dressed?
They were all wearing street clothes, like they had been up.
At 4:06 in the morning?
That's correct. All but I believe 1 female.
Okay.
America sweatshirt still present or gone from the premises?
Sustained. Well, actually overruled that particular question.
What?
Go ahead.
Oh, Duff.
The male in the brown Fan America shirt, he was no longer at the location.
Is that, so you, earlier you described that there were 4 persons inside there at that time, inside the home, that is, at that time.
At that time, when I initially arrived, we had the male in the brown Fan America shirt, the 4 people that I named just a moment ago, and the victim.
Was there ever a time that you spoke with anyone else?
Yes,
What were their names?
if I go to the report.
Sure.
So while at the location, a Kanisha Harris arrived.
How was she dressed?
She was dressed in street clothes.
Did she come into the house?
Yes,
What was her demeanor?
she was upset as well.
About how old did she appear to you?
About in her 20s.
Okay. Did she come alone?
I'm not sure.
All right, I want to talk about your activity inside of the home a little bit further. While inside of the home, can you describe the interior of the home for the ladies and gentlemen?
The interior of the home had what looked to be other bullet holes in the wall into the interior, but it had been plastered over and covered each individual hole.
And when you say plastered over, can you describe a little?
He's
bit more
clearly
detail?
reading from the report while answering.
Like repaired, the bullets came through the home, and then someone came through and put drywall plaster over each individual home or hole.
And did you also see new bullet defects inside of the home that weren't plastered?
Yes.
Did you? Do you have personal knowledge of when those older bullet defects were present when they got there?
Yes. Well, I did a premise.
Personal knowledge,
Oh,
personal.
no.
Okay. Was there a time that you exited the home at 1428 Adele Avenue Southwest?
Yes.
All right. And what, if anything, occurred at that point?
I spoke to a resident who lived in the neighborhood.
What was that resident's name?
If I can go to the report. Anthony Travis.
And about how old did he look to you?
About in his 20s, maybe upper 20s.
Did you initiate contact with him, or did he initiate contact with you?
He initiated contact with me.
All right. What, if anything, did he tell you at the time he initiated contact?
Objection, Your Honor, calls for hearsay.
May I respond, Your Honor?
You may.
That he is, in fact, present sense impression, and it is also going to be an effect on the listener himself.
Your Honor, it's neither of those two things.
Hang on. Let me hear what he's saying.
What he is going to testify, what I am saying, we expect the testimony to be, is going to be tantamount to a present sense impression. If I may approach to further clarify, I don't want to put that on the record.
Do you want to come up to the bench?
And that gets us to sidebar counter number 247. Jesus Christ. Today seems to amount to a day with absolutely worthless testimony and leading questions and hearsay and this and that. Skip ahead.
Can go by for it to. And officer, you're welcome. Conferences quickly, and it's a good time for break anyway. And officer, you're welcome to just get outside for just a few minutes.
Okay, so apparently this was serious enough to you get out, witness, get out, and we get to hear something interesting.
A present sense, take a look at that case since we're all just looking at it for the first time, because a present sense impression exception doesn't have to be somebody perceiving it at the actual time they are telling about it, the actual time they're perceiving it. It can be, but it can be immediately after as well. So the question is sort of like, how much time can go by for it to still be considered immediate? And I don't know if you know what you expect the witness to testify to, but.
Oh. Now this witness is outside reading the report to make it sound less coached.
And Your Honor, may I ask the court for the insight related to that case, if I would, Your Honor?
Did you say 370 Georgia 757?
That's correct, Your Honor.
And I don't know, was there a pinpoint site?
In Division 5.
All right. Do you have any idea what did you expect the witness's answer to be when you asked him the time that elapsed?
I expect that he will say that it was sufficiently close enough for the exception to apply in this particular set of facts, Your Honor. But I will say that I will not make a misrepresentation to the court. I will do as the court is instructed. Nonetheless, while still reading this case law to further bolster my belief or the state's expectation that and support that it's sufficiently close enough in time.
Okay, well, I doubt if he's going to answer the question. It was sufficiently close enough in time in order to get this within the exception. I'm asking, can you step back out? I sort of gave you that instruction as though it was an option, but we'd actually like for you to stay out till we call you, but you didn't know that.
Oh, the witness heard that?
370
Oh,
Georgia
crap.
757 and nothing's coming up. Georgia appeals. That makes a difference. Okay, sorry. So do you have any idea, Mr. Brown, the amount of time he's going to say elapsed?
I would say about 20 minutes, but I'm gonna confirm that before I stick that in.
Well, I mean, obviously, but okay, well, I don't know if 20 minutes is going to get you within the
At the
exception.
most, I should say.
I guess we'll see what he says, but.
Court has an opportunity.
Um.
Your Honor,
Yes, sir.
when the court has an opportunity, what I would suggest, and what is probably appropriate is for the prosecutor to give the court, I think you asked for this, a proffer of what the witness would say. The
Mhm.
Brantley decision does give, in Division 5, gives a pretty specific definition of present sense impression. And I don't know that there's been a case that says, well, 5 minutes is good, 20 minutes is good, 25 minutes is good. I don't know. I've not seen one that goes with that much specificity. But I think the case is clear, and the case law, other than Brantley, is clear that there has to be a significant amount of, use the word contemporaneity, if that's a proper word, has to be sufficiently contemporaneous to be free of any sort of misrepresentation by the witness. And although it doesn't have to be immediately contemporaneous, the witness doesn't have to be making a statement right at the time they're observing it. I think the case is contemplated that it has to be made very soon in time thereafter. And at this point, without a proffer, we just don't know what time period we're talking about, so that we know whether it meets the definition of not.
Okay, well, yeah, I see substantial contemporaneity, which that's a word I've never heard before, of the event and the statement to negate the likelihood of deliberate or conscious misrepresentation. So if that's what we're evaluating, then this may be within that. So thank you for pointing that out.
But then you need to read the entirety of that case to know the
Is there any
time
indication
frame.
in this Brantley case how long past the event the grandmother's statement was?
I'm looking.
To include, they have unhelpfully declined to include that information within the case, it appears.
I do not see it, Judge.
So,
Your Honor,
yes, sir.
If I may, at this point, I just want to turn the court's attention to 4 Kappa, which has been admitted into evidence. It is the call for services report that was admitted prior to this witness testifying.
Okay.
And the court inquired as to the amount of contemporaneity
Uh-huh.
that took place between the statement and the call.
Uh-huh.
And with that exhibit, I do have an answer, Your Honor.
All right.
The call was received at 4:06, and Officer Pierce arrived at 4:08.
Okay, right. So I'm asking, any idea how long after the event he spoke with whomever this witness is?
I
And
can ask-
you were saying you think within 20 minutes, so.
May I ask for a moment to speak with witness to get proper explanation?
Shh,
No,
No.
No.
Our position would be bring the witness in. Let's have the witness answer that question.
yeah, agreed. You can just ask him to step back in.
so this prosecutor tried to sneak in. Oh, let me go outside to ask him. Or please tell me it was within 10 minutes.
If he knows.
All right. It's a little different. It's not a couple people sitting over here.
Okay.
I have a couple of questions to ask you for the court's purposes. If you recall, around or about which time do you recall the call coming in for service?
We already know that. Just get to the point.
Sure. Do you know around or about the time that elapsed between you arriving to the scene and speaking with Mr. Anthony Travis? Was it hours or was it a few minutes?
Minutes.
Leading.
Y'all want to ask him anything about that?
Yes, please. May I?
You may.
May I stay here, Judge? If I speak to
You
my-
can, yes.
Officer Pitts, is it?
Yes,
All right. On that note, were you the person that spoke to Anthony Travis?
yes,
And you indicated previously you got to the scene and you went inside, spoke to some people. So give us an estimate as best you can from the time of your arrival to the time you actually speak to Mr. Travis, or he comes to you. How much time had passed?
Maybe about 15, 20 minutes.
15 to 20 minutes?
All right.
Oh, that's a different answer than the leading question from the prosecution. Was it hours or minutes? Minutes. Okay, but there's quite a big difference between within 2 or 3 minutes and 15 to 20 minutes.
Thank you. You can step back outside. All right. My ruling would be that's close enough in time.
Of course it
to
is.
negate the likelihood of deliberate or conscious misrepresentation.
Do you know how much you can talk with other witnesses and make up a story in 15 to 20 minutes? Let me give you the Woody testimony. He got a name, and within half a second, he made up a whole story. Yeah, 15 to 20 minutes, you can invent a lot of things. That is, in my opinion, this is a bad ruling.
Representation. So I'm going to permit that as a present sense impression exception to hearsay. Does anybody need to use the restroom before we have the jury back? All right, let's all take as quick of a break as we can because we've already been out about 15 minutes. Thank you.
I see, one of my same colleagues across the aisle here, I believe that he is here as a representative for one of our businesses. And I kind of spoke to him.
Oh, okay. Now we have QZ's lawyer that he retained this weekend, so we can listen to it.
All right, what's your name? Okay, I'm sorry, I hadn't seen you in a while. You looked familiar to me, but
Everybody thinks I'm dead.
okay. Are you asking to approach without the defense?
No, make a mistake. That's fine. That's one from the record. I'm representing Mr. Zachary, and I can't do is picked up on material witness. I would ask the court to release him. He's got sickle cell bad. When he was picked up, he just exited the hospital. They had to do 2 blood replacements, transfusions. He's in hospital, or he's in Brady right now. That Brady, he's in Polk County Jail. He's got pneumonia. He will not live, Judge. I talked to the family. In the last 4 months, he's been 10 out of the hospital, 10 out.
Okay, so he says, this lawyer, sickle cell and pneumonia. So pneumonia was the pre-existing condition before he went to jail. I thought he attracted pneumonia in jail. No, he was that sick before this inhuman put him in jail. You despicable, evil human being.
He's extremely sick. He will not survive. I would ask that he be released, and I'm going to be in touch with him. He will come to court when you ask him to come to court.
Go ahead.
If not, he will leave.
All right, so the information I got this morning, and y'all, this is actually what I wanted to discuss on the record, had we, at the bench conference, had we gotten started at 8:45, like I asked for us to get started. So anyway, no, this has nothing to do with that. But the information that I got this morning from the sheriff's office was that he is in Grady.
Your Honor,
So I don't know how recent your information is.
I talked to family 2 a.m.
well, we've spoken with the sheriff has informed us since that time, and that was what I wanted to bring to the court's attention.
Okay.
So between 2 a.m. and 8:45 a.m., they took him back to the hospital. I don't, if it was Hilton or if it was Love, it's the same person at this point in time. Sickle cell and pneumonia, and they put him in Rice Street, the prosecution. And then he was released to hospital, and nobody told either the family or his lawyer.
I didn't know that.
Judge, and I think that this is a matter that I can speak with Mr. Shive about. I don't know if he wants to fully flesh it out now, but I did want to approach the court with the information and the defense with the information we had. There's more information than just that.
Okay, why don't we just, let's have a bench conference, but I would like to be able to just talk about it without them all huddling at the bench. So just don't record this, please. And you're not supposed
Oh, yeah, of course. No, this is information that should be accessed by the public. Because if you can speak in court about it with audience, then you can speak on camera so everybody really finds out the evilness of the prosecution. Let's see how long they were gone. A good half hour. This is
Okay, well, did you just find it after I said, is there anything else before we get the jury in? Okay, give it to me really fast.
364 Georgia app 518 Grimes versus the state 2022 case.
So, Ms. Brown, did you hear what he just said?
Yes, no.
Sorry? Well, you know what? I'm sorry, but you didn't introduce yourself, and so I was just taking a stab at it. What's your name? Okay, so what was wrong with me saying Mr. Brown? No, I didn't. I said Mr. Brown. I just slide my words into each other sometimes. So, okay. Thank you. You can be seated. Okay. Well, I'll try to look at it on the fly here, and
What was that pin site, since we can look at it?
Hmm?
That pin site that he provided before?
I don't know. Is there a pin side?
so apparently
Sorry, y'all. I thought we were ready, but of course, after I say bring the jury, we have some more. Oh, wait, here's some more. Thank you.
the arrest warrant should be public record. Don't know if it is in. I'll check somewhere.
Had a chance to take a look, to respond. I'm so sorry, y'all.
Thank you, Casper. Acute pulmonary complications of sickle cell anemia happens frequently. NIH 2021. Yeah, I would imagine so, because oxygen transported through your red blood cells, and this particular illness makes the red blood cells go bananas, literally, which affects your immune system, which affects how you can go around on your day-to-day, and it's apparently very, very painful in some cases. So them putting him in Rice Street over the weekend, while yeah, ahead.
This doesn't seem to impact where the state stood as it relates to the last break. Additionally, I'll just say, Judge, while contemporaneity is understood to be, in fact, a part of the analysis, a reference to a citation from Carlson's Rules on Evidence further advises that precise contemporaneity, though it's not required.
We know that already, so that doesn't shed any additional light on the subject. All right, why don't you just ask the leading questions and focusing on what matters with regard to this exception, and I'll see how it comes out.
Welcome back, Officer Pitts.
Hello.
All right. All right. Before the break, you indicated that you spoke with an Anthony Travis. Do you recall that statement?
That's correct.
All right. Can you tell the ladies and gentlemen of the jury what it is that you spoke with him about?
Mr. Travis said that before the shooting occurred, there was a
The subject matter, not what he said.
The subject matter, without saying what he said.
he witnessed the shooting occur.
All right.
Is this person going to testify?
Did he describe, if at all, if he saw the person who conducted the shooting?
He did.
Okay. Were you able to, from that conversation with Mr. Travis, were you able to make out a description of what the person he saw without saying what he said?
So what I want you to focus on is what would make a difference with regard to this exception, time and.
I will withdraw that question and ask a different one. What did he describe that he saw? Hold, 1 second.
Seriously, prosecutor, whatever your name is, because you're not important enough to me to care? This is not hard questions to ask.
How long after you arrived to the scene of the incident did you
Asked and
interact
answered.
with- How long after you arrived to the scene of the shooting did you interact with Mr. Travis? How long after?
About 15, 20 minutes.
And did he
Yes,
give details
go
about
to-
what he
go
saw
to-
regarding the shooting that took place prior to your arrival?
He did.
And
This guy is making in excess of $100,000 a year.
Was Mr. Travis able to describe what the shooter did?
He was, yes.
Okay, all right. Was he able to describe to you at that time the methods of transportation, if any, for that particular shooting?
Yes.
And earlier you talked about the ages of the persons you interacted with that day.
Yes.
Do you recall the dates of birth associated?
Not off my memory, I would need my report.
Okay, I am now approaching you again with what has been pre-marked as State's Exhibit 500R. And want to give you this exhibit again. And when you've had a moment to refresh your recollection, please look back up at me when your memory has been so refreshed.
Yes.
All right, so what is the date of birth for the victim, Ms. Denise Bell?
January 21st, 1956.
Based on that date, will she have been in her mid to late 20s?
No.
Okay. What about the dates of birth for the other persons that you interacted with on that early morning of April 28, 2015?
Yes. Miss refreshing my memory. Miss Diamond Mills was born 10/30/1995. Mr. Travis or Anthony Travis, 2/27/1959. Cecilia Davis, 11/13/1962. Diamond Mills, 10/30/1995. Zuranisha Coakley, 7/15/1994. And Taiwan Marsh, 3/14/1997.
Have just a few more questions for you, Officer Pitts. The shell casings that you talked about, you saw earlier, did you ever collect those for evidentiary purposes?
The crime scene tech collected the casings.
And do you recall who that crime scene tech was that came to that scene?
I believe it was Turner. His name was Turner.
And do you know who called him out to that scene?
That would have been me if I'm remembering correctly.
Crime scene technician Turner. That isn't the yellow flag guy, is it? Because he's not really a crime scene technician. He only puts out flags under direction.
And without saying anything that he said, do you normally have any kind of interaction with him prior to him getting started with what he does?
No.
Just a brief indulgence.
Sure.
And it goes back to Grandma Love. What am I asking now,
And
mommy?
around
Mommy?
what time did you leave the scene?
I can't remember.
Okay. And do you recall who all was still there when you left?
No, I don't remember.
And did that conclude your involvement with this case?
Yes.
Your Honor, at this time, say pass.
All right. Are there defense questions for this witness?
No questions on behalf of Mr. Williams.
None. All right, coming up.
Okay, cross-examination. By Mr. Shard.
Hello. Good morning.
My name is Max Shard. I represent Shannon Stillwell. You arrived at the scene and it sounds like within 15 to 20 minutes, you were speaking to a Mr. Travis.
Anthony Travis, yes.
Okay. And Mr. Travis was, to your understanding, not someone that lived in that residence.
That's correct.
Okay. And he approached you on the street as you were leaving?
I believe that he spoke with an officer standby, and then when I got out there, he approached me.
Okay. And he gave you a description of the person whom he saw shooting at 1428 Adele Avenue, correct?
Correct.
He described that, well, and he gave a description also of a car, correct?
That's correct.
He said one car left the scene, one car, right?
That's correct.
Okay. And he described the person shooting a gun that had a banana clip, correct?
That's correct.
Okay. And he described that individual as a black male,
That's correct.
short black male, correct?
That's correct.
Okay. And did you get a height range or was it just short?
I believe it was just short.
Okay. And he described that gentleman as having dreadlocks, correct?
That's correct.
The shooter being short black male with dreadlocks.
That's correct.
Mr. Stillwell is not short.
Yes,
That approach was 410 wide and 413 wide.
you may freely approach the witness, yes.
Could you look at 410 wide?
Yes.
Okay, and I'm not going to ask you the identifications of any of those individuals, but do you see an individual wearing, do you see a date on that post?
Objection, Judge Relevance.
I don't know what,
I'm sure
It
my
is,
client doesn't
so.
match the description.
okay, that was,
So I'm assuming Mr. Shard is bringing up something that tells everybody Mr. Stillwell's height.
an inappropriate way to answer that. I don't even know what the exhibit is, so I can't rule on it.
I would ask that we approach, Your Honor.
All right.
Did they go up to... Apparently, they are just showing the exhibit.
Wide, 410 wide and 413 wide. Could you look at 410 wide? Do you see a gentleman in a plaid maroon and black and white shirt?
Yes.
Does that gentleman have dreadlocks in
Your
that
Honor, I'm
picture?
going to object on the same basis that we had objection. I'll ask for continued objection because for the reasons that were.
Okay.
Does that gentleman have dreadlocks in that picture?
No.
Okay. And what is the date of that post, if you can read it?
4/28/2015.
Is that the same day as this incident that you were?
Shannon Stillwell didn't even have dreadlocks on the day. Oh, that takes care of that.
Referring to in your testimony here today?
Yes.
Okay, I'm going to ask you to look at 413Y and your 413Y. Is that another picture of that gentleman?
Yes.
And you would agree that that picture also shows that he does not have dreadlocks?
That's correct.
Okay, Your Honor, may I just publish?
Ay. Prosecutor, this is so stupid. Why did you put him up there to imply that Mr. Stillwell is the possible shooter when you know he doesn't even fit the description given? This is so stupid. But this is the state's case all the time. It's like they believe, I hope we don't get caught with this pile
Your
of
Honor,
garbage.
Once the jury is done with those photos, I don't have any further questions.
Do any other defense attorneys have questions for the witness? All right, does the state have redirect?
Yes.
Mic back on. All right.
Allow.
All right, I'll give them just a second. And then you may do your redirect.
Yeah, that is why the prosecution was hell-bent. As Amelia Dixon says, that's why he was so hell-bent on Max not asking that question. Yeah, because Shannon Stillwell doesn't match the description. First of all, Shannon Stillwell isn't short. And apparently, April 28th, 2015, he did not have dreads. This is so stupid.
And when you asked to publish, I actually thought you were going to publish it electronically because that's how we've been publishing. And this is fine, but it does take a little bit longer
I apologize. We didn't have the electronic copy
of
available.
this. Okay, it's fine. Present your redirect and just put it back up with the court reporter. That'll be fine. Thank you.
I am starting with State's Exhibit 413, and 413 Yankee, and I am handing it to the witness. I want to ask you a couple of questions about that exhibit, which is in your hand.
Yes.
On cross, you were asked a few questions by Mr. Stillwell's attorney. I want to ask you, do you know Shannon Stillwell?
No,
Do you know when that picture was taken?
the date says, for,
I want to ask you, can I ask the answer to the question? Yes, go ahead.
it's timestamped, yes.
Do you know that was the date that the picture was taken or that the date that it was posted?
I'm not sure.
Right. I want to turn your attention to State's Exhibit 410, Yankee. Do you know Shannon Stillwell in the plat?
No, but I recognize him in the photo.
Okay. All right. Do you know when that picture was taken?
It's timestamped, 4/28/2015, 11:50 a.m.
Do you know if that was the time that it was taken or the time that it was posted?
Oh,
I
come
don't know.
on. The prosecution has, for almost a year now, been putting up photos with no timestamps, with no metadata, claiming it was contemporaneous, it was that, it was this. And now, when the defense puts up a picture with, here's an actual timestamp. Oh, did you know when it was taken? They discovered, what was it, a week ago? 2 weeks ago? That the infamous video clip that the state presented as evidence in the Donovan Thomas killing, that it was, since it was posted after, it must have mean they were talking about Donovan Thomas. And then the defense, no, here's the original, because the prosecution had a repost. and the original was posted before. And here they are, these absolute morons are trying to claim, well, you don't know if it was taken. Ah, Jesus Christ.
Did Mr. Travis show you a picture of the shooter on the day of April 28, 2015?
No.
And on cross, you were asked a few things about what he said. Tell the ladies and gentlemen of the jury what he told you. Exactly what he told you.
Mr. Anthony Travis told me that prior to the shooting, a black vehicle was sitting to the west of the residence, 1428 Adele Avenue. Black male with dreads, short black male with dreads, got out and started shooting at the house with a machine gun that had a banana clip.
Okay, all right. And what, if anything, happened, or did he tell you after the shooting occurred?
He did fill out
No. My question is what, if anything, did Mr. Travis tell you the shooter did after he was done shooting?
he got into the shooter did go back to the same black vehicle and leave in the black vehicle.
Okay. Do you know if Shannon Stillwell was driving that vehicle?
No.
Do you know if Trontavious Stevens?
No.
Do you know if Trontavious Stevens is 5'4"?
No.
Do you know if he wears dreads that are in his head?
No.
Do you know if Mr. Based on the questions that were asked.
I'm gonna object as to leading.
Sustained.
You're on the mayor's.
You can rephrase your question.
All right.
Jesus
Have you ever
Christ.
seen the pictures that were placed in front of you at States Exhibits 413 Yankee and 410 Yankee prior to Mr. Sharp showing them to you today?
No.
What, prosecutor? Are you mad they existed? I'm quite sure you knew about the April 28th pictures of Mr. Stilwell. You had to have known. It's in freaking Discovery.
And do you know whether or not Trontavious Stevens is a member of YSL?
No.
I do have a few more questions. You testified that there was a banana clip that Mr. Travis described to you, correct?
That's correct.
All right. In your training or experience, is banana clip the type of formal terminology used to describe such things?
It's the improper terminology for a magazine.
When you describe a magazine, what do you have? What do you understand? Or what do you communicate to the jury?
In reference to this report with Mr. Anthony Travis, I believe he was talking about a rifle magazine, kind of similar to the one I have mounted on my vest.
How is it shaped?
How the frick would he know what he meant? That is misinterpretation. I mean, this is so stupid.
In the shape of banana.
And what is the purpose of this magazine or banana clip, as Mr. Travis described?
It feeds ammunition to the firearm.
It's the shape of
uh,
the magazine, you
Mr.
not.
Travis tell you at that time whether or not he knew the shooter had emptied the magazine or the banana clip?
No.
And what kind of rounds would be put inside of a magazine for a rifle?
223 762.
And what?
No, this is pure speculation. If you don't have the actual gun, you cannot base what ammo, what it was in that gun based on what was, because you don't know if that whoever that person was on the street claiming, oh, I saw it happen. This is pure speculation.
Shell casings were found on the scene of the shooting, crime scene of 1428 Adele Avenue Southwest.
223 762.
And when Mr. Travis described to you what he observed the shooter to do, did he tell you if the shooter got into the driver or passenger side of the vehicle?
I don't remember if he told me.
And based on your training and experience, about how many rounds can a magazine for a rifle hold inside of it?
With a, depending on the type of magazine, 223 magazine can typically carry about 30 rounds.
And about how many rounds, shell casings were found on the scene to your recollection?
32.
Do you know how many people were inside the vehicle based on what Mr. Travis communicated to you on that evening?
I do not.
I have no further questions.
All right, Mr. Shard, any recalls? All right, thank you for your time, officer. You are excused. Call your next
Dear-
witness.
This was
Right, at this time, the state now calls to the stand. Crime scene technician Alfred Turner.
Alfred Turning, crime scene technician, is the next witness. Jesus Christ. Yeah, they were trying to bury. I mean, how can you forget that a picture of Mr. Stilwell that day, where
Can all the
he is not
attorneys do
short?
everybody a favor and have, when you know we're going into this sort of redirect, have your witness at the door ready to walk in, please.
I do.
Crime scene technician Turner at
It's Alfred Turner, Alfred Turner.
Good morning, Mr. Turner. Are you employed?
Yes,
And where are you employed?
City of Atlanta Police Department,
And how long have you been with the City of Atlanta Police Department?
30 years.
And what is your official title at Atlanta Police Department, at the Atlanta Police Department?
I'm a crime scene supervisor.
And have you always been a crime scene supervisor?
No,
What was your title prior to becoming a crime scene supervisor?
I was a crime scene tech.
Okay. And what do you do in your current capacity as a crime scene supervisor?
What I do is I supervise a team of 5 crime scene techs. And what I do is I monitor their ability to collect evidence, process evidence, and testify in court.
And what were your duties as a crime scene technician?
It was similar, except I wasn't supervised then, but I had a supervisor at that time.
And when or about did you become a supervisor at the Atlanta Police Department's crime scene technician department?
That was in 2015.
You remember the month?
I believe it was like an August, maybe.
About how many crime scenes would you say you've processed in your 30-year career?
Maybe around 7,000, 8,000.
How do you ordinarily become aware that there is an active crime scene for you to process?
What we do is we monitor a radio on the main channel, and we are dispatched through the department by a zone officer.
And what does it mean to secure a crime scene?
Secure the crime scene is usually what the officers do. What they do is once they call us to a scene, then they actually stand by and just monitor the evidence and victims who may have been involved, and then they call us out to start to investigate it.
Why are crime scenes secured?
They're secured so evidence won't go missing.
And what is crime scene tape?
Crime scene tape is
Oh God, this is boring. Do they at least show pictures? Yeah, I can't be bothered with this. Ah, look, they show pictures.
Kaplan and crime scene Turner, you will see a calculator screen behind you and on the laptop before you. So
Okay.
Samantha Yo says yes, keep him. Yeah, so that means nothing interesting happened with this guy. Okay, bullet, bum, 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 gunshot, shell casings. That's a nice home.
And ladies and gentlemen, we
of the camera that
On behalf of Mr. Williams, we have no questions.
Okay, no cross-examination. That means this
Mr.
witness
Williams, Mr.
is
Hardy.
not interesting at
Okay,
all.
Thank you for your time. You are excused. And this is probably a good time to break for lunch.
Okay. Jury sent out. Let's see.
Ladies and gentlemen, we have some matters to deal with over the lunch hour, as is not atypical in this case. So I'm going to give y'all until, let's see, it's 1:30.
Oh, that was a long ass lunch based on when it started.
Laura. Some matters over. All right, we're gonna need to take up some matters over lunch, and Ms. Hilton needs to be here for that. Is she readily available or?
I'm actually, when I saw the email, I was sending word to that.
Miss Hilton really needs to be there. Well, since apparently Miss Hilton is the person who asked this judge to put out the arrest warrant for QZ, I assume it's about that one.
Come over, and she's available to come over.
Okay,
Trying to, there was also the matter of preparing and getting to the court, the correspondence, she was collecting all of the correspondence she had, and we had it ready, we're getting it into the court now too as well.
okay.
And so yeah, we can address at lunch as soon as she gets here, everything else. I think there were other matters I want to discuss. I didn't call permission to speak with the witnesses attorneys about,
Mr. Zachary's attorney?
yes, so that I could address the court regarding.
So this is about QZ.
Okay, well, that's not what I wanted to address, but I need Ms. Hilton here for it. Gotten a very interesting email. And I'm going to want to discuss it as a bench matter, but it is very difficult to have everybody huddle at the bench. So when Ms. Hilton gets over for us to discuss that, I'm just going to ask that the media and the audience be excused because you wouldn't normally hear what goes on with a bench conference. It'll be taken down for the record, but it's just too difficult to have a serious, involved conversation huddled around very little space. So why don't you?
Across the United States, a crap ton of judges does not have the need to keep things like this a secret. And since it's already been determined that this trial is going to be public with cameras, why are she all of a sudden instructing everybody to leave? This is not an ex parte meeting at all, since everybody will be there. So why the flaming F is she starting to do this now? Keeping secrets. Well, hopefully by the end of, after trial is done for today, we will at least find out something from the people involved, at least what it was about.
Do you know whether the lunches are here? Why don't we take 30 minutes so that the defendants can eat lunch and then reconvene? Okay. And if the hard copies for the in-camera inspection are ready before then, can you just have somebody to deliver them to my chambers, please? Okay.
We combined them as a those PDFs. The court is inclined to receive them electronically.
So y'all gave them to me electronically, what, I think on Wednesday or either Thursday morning. And I said, this is incredibly difficult to sort out electronically, which is why I asked for hard copies. So unless they are amazingly way easier to sort through and set parts aside now, yes, I'd like them as hard copies.
So we are going to give the court hard copies, of course, but the
Well, you say of course, but you were supposed to have given them to me this morning.
So, Your Honor, what the court got last week was
Yes.
every email just in one combined email. And what we have done now is actually sorted through, taking out anything that wasn't directly related to negotiations and combine them chronologically in a PDF as it related to each defendant. That's what we were providing. We were trying to clean that up.
Well, that's
So lunch started with Prosecutor Love not doing what the judge asked her to do. Nobody is surprised. Okay, let's skip lunch. Jeez. Okay, I'm turning this up to 1.5 so we can get through this. Now back from lunch. Oh, Yeah, but that is like 2 years from now. But yeah, I can do it. Oh, sidebars in this case.
Thank you. I have had a lunch
Seriously.
and the state has got their next witness in here. Let's go.
These sidebars in this case will be epic. Epic. But we will have to wait, and then somehow we need to be able to pay for the transcript of the sidebars. And 247 of them, $1 a page. I would assume, folks, we are talking about in the thousands for sidebars alone, maybe more. But when we get there, maybe this channel has blown up yeah, and I can afford it. But we will see when that time comes.
Go ahead and swear this witness.
Raise your right hand. This is my first. That's when we do the truth. We'll do number two. State your name. Have to state your name out before.
All right.
First and last.
All right. Officer Hill, Sean, S-E-A-N, last name is Hill, H-I-L-L.
Good afternoon, Officer Hill. How are you doing?
I'm doing good about yourself.
Doing well.
All right.
Can you tell the jury how long you've worked with Atlanta Police Department?
Yes, sir. I've been an officer for a little over 12 years,
What year was it that you graduated the academy?
2013.
And how did you end up working for APD?
Long story short, I was military and
I don't claim to know much about American culture, but I have on occasions, thanks to my significant other, been forced to look at music shows. Is that T-Pain? Or am I way off? Doesn't he look like T-Pain?
I came into law enforcement after I got military,
What branch were you in?
Marine Corps.
And was it through a connection in the Marine Corps that you ended up working for APD?
Yes, sir. One of my coworkers in the Marine Corps came to APD when he got out and he recruited me to the department.
What did you do in the Marine Corps?
Uh,
Your Honor, it's foundational. Jury has to determine Officer Hill's credibility as a witness.
Sustained. I mean, overruled. You can go ahead and just briefly do it. We don't,
Yes, Your Honor.
as relevant to his position as police.
How does he, being in the Marines, a Marine Corps, now, thank you for your service. Maybe he is a better officer for it. But what does it have to do, unless he has specialty training? It has no bearing.
Police officer now.
Yes, Your Honor. I'll ask more pertinent questions, Your Honor, related to that. Officer Hill, what skills did you learn in the Marine Corps that help you as an officer with the Atlanta Police Department?
I learned valuable skills, patience. I learned a lot of stuff in the Marine Corps.
And what, in non-military terms, what was your job? What did you do?
I was communication operator, radio guy,
Now, Officer Hill, what zone do you work in currently?
Zone 1.
And are you a patrol officer?
Yes, sir.
How long have you worked in Zone 1?
My entire time as an officer for 12 years.
Now, how many
Patrol officer for 20 years. Okay, so another one who can't climb the promotion ladder.
beats are in Zone 1?
It is 14 beats.
And how many of those 14 have you worked?
Every last one of them.
And are you assigned currently to a specific beat or all of Zone 1?
Pacific beat in Zone 1.
And which one is that?
113.
Now, are you currently post-certified?
Yes, sir.
And Officer Hill, were you post-certified on the night of April 27th going into April 28th of 2015?
Yes, sir.
Can you describe for the jury briefly, what type of cases you have handled working in Zone 1 over these 12 years?
Yes, sir. Anything from domestic violence to break-ins, car break-ins, burglaries, people being shot, damage to property. So anything you can think of, it happens in Zone 1.
And throughout the 12 years of working in Zone 1, have you got familiar with the neighborhoods in the different beats within that zone?
Yes, sir.
So I want to turn back to April 27th, going into April 28th of 2015. What beat were you working back then?
That was 110.
And what's the precinct location for beat 110?
It's off of Donnelly Hollowell Parkway.
How close, or what's the address on Donnelly Hollowell Parkway for that?
Precinct is 2315.
And are you familiar with Club Crucial?
Yes, sir.
How close is Club Crucial to that precinct that you were working that night?
Maybe like a couple hundred yards.
Now, What time or what was your shift, or were you working that day?
Yes, sir. I was working today, and my shift was at 10 p.m. that night to 7 in the morning the
So
next
you,
day.
so you would start 10 p.m. April 27th, going till 6 a.m. April 28th?
Yes, sir.
Now, were you in uniform?
Yes,
And would you have had a patrol car?
yes.
And back then, did you ever have a partner, or were you working your
No,
single patrol car?
just solo.
Now, coming on shift that night, do you remember ever responding to any calls that stood
Oh,
out?
I'm putting it back down to 1.25. This is a bit too fast.
Yeah, we had a shots fired call, and I think a fight call at Crow Crucial that night towards the beginning and middle of the shift.
Ballpark, rough ballpark, do you remember around what time that would have been?
Between 12 and 1 in the morning.
And did you respond to that call?
Oh, yes, sir.
Did other officers respond?
Yes, a lot.
Now, when you're responding to Club Crucial, have you responded there before in the past?
Yes.
And what were you responding to on?
The fight at Club Crucial has been testified to by several people. Why is this specific witness important? This goes again to why is the state putting on witnesses that has nothing to add? I mean, and remember, these are the witnesses the prosecution claims they have to have. But the fight has already been testified to. Jesus.
The night of April 27th going into April 28th. What type of call was it?
We had shots fired in the area, and we had large group of people fighting. That's what the call came in as.
And how extensive was your involvement with that Club Crucial call and wait for your shift?
That night, my job was basically just to get everybody out safely. So I was out trying to get clear the parking lot and get everybody on the road.
Now, after responding to Club Crucial, did that impact how the rest of your shift would go?
Usually we have incidents that happen in Crucial that carry over into the neighborhood. So yes, we were on alert that night due to the shots fired in the fight that happened in Club Crucial.
Now, Officer Hill, after you responded to, or let me ask you this, that night, because you were in beat 10, would you show up on, or would you be 1110 on a CAD report if you were working beat 10 in zone 1?
Yes.
And would other officers you said that there was 14 beats in zone 1,
Mhm.
would it be reflective of 1 through 14?
Yes.
Okay. Now, after you responded to Club Crucial, did you ever have the opportunity to go to 1903 Drew Drive?
Yes. I responded to a call at 1903 Drew Drive later that morning, like around about 5 that morning.
After you'd responded to Club Crucial?
Yes.
Now, what area had you been to Drew Drive in that area before?
Yes.
And by this point, it'd be April 28th, 5 in the morning about around that time when you responded to Drew Drive?
Yes, sir.
Back then, in April 28th of 2015, how would you describe that area that Drew Drive is within your beat?
It was a quiet area, nice, fairly new, renovated. So we didn't really get too many calls in that area.
What type of calls had you responded to in that area when you responded that morning?
Because
Your Honor, it's setting a background for Officer Hill's familiarity with his specific beat that night of the shooting.
Sustained.
Now, Officer Hill, when you responded to Drew Drive, how far was it from your precinct?
it's like a 5-minute drive.
How far is that from Club Crucial?
Same, about 5 minutes.
Now, when you got there, were you at a house, a residence, an apartment? What was there when you arrived?
It's both, but the actual 1903 is apartment complex.
And when you got there, was it light out or dark out when you first got there?
No, it was dark.
And let me ask you this. When you first got there, who did you see or encounter?
The caller, Miss Battle.
Okay. And was there anyone else other than Miss Battle that you interacted with when you first got on scene?
Not initially.
Now, Officer Hill, without mentioning what she told you, what was...
And I'm also gonna, I don't know, we haven't talked about this before, but please just refer to her by her last name, okay?
Okay.
And I don't know that you've done anything other than that, but.
Yes, Your Honor.
Okay.
Officer Hill, without stating what Miss Battle told you, what was her demeanor when you encountered her?
She seemed like she was frightened, scared.
And did you talk with her outside or inside that apartment, if you remember?
I don't remember that at that moment.
That's all right. Now, after speaking with her, did you go anywhere within that apartment complex?
Yes.
Where did you go?
I went to her, the call her apartment was damaged from a rear balcony. So when I entered the apartment, I went to the direction of the rear balcony. She pointed out where her damages were, and we was like in the living room area of by the balcony.
And was her apartment, was it on the first floor, second floor? Or?
First floor.
Now, did you know before speaking with Ms. Battle what kind of call you were responding to initially?
Yes.
What kind of call was that?
It was a shots fired call.
Now, Officer Hill, I want to approach you with what's been marked as State's Exhibits 3 Lima Lima through 64 Lima Lima. Now, Officer Hill, if you can do me a favor and flip through from 3 Lima Lima through 64.
This seems to be one of these transition days that we just have to go through, where the prosecution is doing something.
Lima Lima, and when you're done, just look up at me.
Yeah, for SM1, what does info about the victim matter if we don't have testimony about who did it? I don't know. I honestly don't know. But this is the state's case. This is all they have. Be prepared, but not coached. At least we can skip ahead.
Yes, sir.
What are those? 3
Just
through 64.
photos of the damaged property and some of the shell casings that we recovered from the scene.
Are they a fair and accurate of the photographs and the scene that you responded to on April 28, 2015?
Yes, sir.
Your Honor, at this time, the state moves to admitting to evidence State's Exhibits 3 through 64 Lima Lima.
They're admitted without objection.
Thank you, Your Honor. Now, Officer Hill, I want to start with 3 through 12 Lima Lima. What apartment was Miss Battle's apartment? After speaking with her, you said you went inside. What apartment was it that you all went to?
Apartment 1122.
And once you, so I want to publish State's Exhibit 3 Lima Lima first.
Haven't we already seen and heard about this? I'm quite sure we have.
Now, Officer Hill, you had said she was on the first floor, apartment 1122,
Oh, yes, sir.
and turning to 4 Lima Lima. Is this 1122 the apartment you went to with Miss Battle that night?
Yes, sir.
Now, can you describe for the jury, what did you see when you went inside? I'm going to publish 5 Lima Lima, or I'll take a step back. When you had first mentioned her back porch, what was the damage that you noticed, if any, on Miss Battle's apartment porch?
You can tell that her back door was damaged, had glass shatter throughout the door. So when I went in, she pointed me in the direction, and I was able to see where the bullet made.
How is it that they had to have both these cops testifying when one could have testified about everything here? This is so stupid.
Entry. And I just traced the direction and noticed that it went through her couch as well.
I'm gonna walk through a couple of these photographs with you, Officer Hill.
Okay.
Publishing 7 Lima Lima. Can you orient for the jury? Do you see the damage you had just referenced in 7 Lima Lima?
Oh, yes, sir.
And where is it?
It's toward the bottom of the door or glass.
Is it where that blind is?
Damaged it. Yes, sir.
And once you trace that, can you show the jury on publishing 8 Lima Lima where that bullet?
Yeah. So the bullet, when the inmate entered through the door or the glass, it went directly to the, I guess, the couch cushion, like where the armrest is at, and it went through the pillows.
I'm gonna publish 9 Lima Lima. Is 9 Lima Lima, is that the inside of Miss Battle's apartment door, 1122?
Yes.
And 10 Lima Lima. Can you describe for the jury, is this the couch that you were just discussing with them about the bullet hole?
Oh, yes, sir.
And 11 Lima Lima. Where did you notice the damage in Miss Battle's couch in 11 Lima Lima?
Right at the bottom part of the arm cushion. Yeah, that's where the damage went, the bullet went through.
And 12 Lima Lima, do you see any debris or that you saw that night in Miss Battle's apartment?
Yes.
Can you describe for the jury where that is?
It's right in between on the bottom right of the pillow, in between the green and red circles.
You direct my mouse, or you tell me, you talking about towards the right of where that clicker is?
Yes.
Yeah. Seriously. This is not in. I mean, hey, yellow flag guy. I don't think they will recall yellow flag guy, but let's see. Did I keep it here? No, I don't think I did. All right.
2 Lima Lima, can you describe?
I want to find it. Hold on. With this picture up. Remember that photo? And
Yellow flag guy in the morning light. Not quite sharp, but he's trying right. Marks the clues with yellow signs. Never solves the case, but keeps us alive. He walks around with his flag in hand. Marks the spots like he's in command. Yellow flags on every scene. He's a part of the team, though he's rarely seen. Yellow flag guy, that's his name. Not a mastermind, but it's all the same. Does his part in his own small way. Yellow flags make sure nothing strays.
yeah. All right, let's get on with this.
Jury, in general, what this photograph depicts.
Yeah, so everywhere you see a yellow marking on the ground is where we recovered a shell casing from.
So are all of these yellow placards in the street outside of 1903 Drew Drive indicative of shell casings or projectiles in the street?
Yes.
Publishing 63 Lima Lima, is this another view of those shell casings in the street?
Yes.
Now, Officer Hill, while the crime scene tech was there, there's a number, or how many, well, I'll do this. You see that this is placard number 1 and 32 Lima Lima?
Mhm.
I'm gonna publish 61 Lima Lima. Publishing 60 Lima Lima. And Officer Hill,
Oh, for frick's sake. I can do without this. I mean, oh, another one. And he's off the stand. Next witness is Courtney Daniels. Yeah, I can't be bothered with absolutely worthless. I'm glad I started a bit later, but what's going on here? Are they painting the picture? Apparently, no notifications has been sent out of this stream because, I mean, the last 3 months, I have had somewhere between 150 and 400 continuous viewers. At the moment, on YouTube, I have 40. So apparently YouTube decided to shadow ban me today or something. Because usually these are numbers. Yeah, I don't know. If you have social media, I wouldn't mind if you shared. If you have X, go to X. You will find my postings there and you can retweet and stuff like that. Okay. Because these numbers are horrible at the moment. Yeah,
So our first testimony, give it the truth, the whole truth, and nothing but the truth.
Yes.
Have a seat. State spell the first and last name for the court. Slide into the mic, please.
Courtney Daniels, Daniels.
And good afternoon, Ms. Daniels. Where do you work?
Verizon Wireless,
And how long have you been with Verizon Wireless?
10 years.
And if you could tell the jury briefly about your job duties and responsibilities.
I'm a custodian of record, so I handle testifying in criminal as well as civil cases. We also handle small claims, mediations, arbitrations, and other executive complaints that
okay.
come in our
So
office.
phone
And you
records.
said that you're the custodian of records. What type of documents would be within your purview that you testify to?
So we testify to subscriber information, call details, text message content, any internet records that are available.
Okay. So first starting with call detail records, if you can tell the jury when you, the call detail records that are with Verizon Wireless, generally what time zone are those call detail records kept in?
Call detail records are based on where the user is located, so it's based on that time zone.
So for example, if you have call detail records for a phone based out of Georgia, would that be an Eastern time zone?
Yes.
And you also talked about you keep records with text messaging content.
Yes.
What time zone are those text messages usually kept in?
So text messages are, the time zone is based on the switch where these, which is the brain of the network, where it's located. So that's how we tell what the time zone is for the text message.
And the documents that you talked about that you may testify to, are those documents kept in the regular course of Verizon business?
Yes.
And is the information contained within those records made at or near the time in which the calls or texts are made?
Yes.
Specifically, we talked about subscriber information. Is that document kept within the regular course of Verizon business?
Yes.
And we
Ms.
talked about
Hilton
the
is
call
back.
detail records, same question, kept in the regular and ordinary course of Verizon business?
Yes.
And then text message content, are those kept in the regular and ordinary course of Verizon business?
Yes.
With the call detail records, do you also provide cell site information?
When requested, yes.
Okay, and what is cell site information?
Cell site information tells us what towers were involved in.
Oh, God, no. She's a custodian's keeper. So this means it's just oh, and they, break, come back. All right. Yeah, I suspected so. She is just entering this into evidence. She's not interpreting them. She's just a custodian, not the technician or expert. She's just a custodian. So I don't care. Well, today will be I mean, let's see. After the next break, did they have a?
Yeah, I think a couple of the jurors are gonna come grab their things that they might have left out here, and I'm gonna excuse them for the day. So let's.
Oh, really?
let's let them do that, and then we'll take the recess, and then we'll reconvene.
Okay. They are sending the jury home. Okay. Then what? Then what?
Thank you all.
Okay, this, at the other hand, might be interesting. If this is some kind of evidentiary. And Mr. Shard is already standing. Okay, this would be interesting. I hope, at least. I really, really hope. Yeah, for SM1. Yeah, Hilton needs to explain how someone can be arrested and held in jail until they are called to testify when they aren't guilty of a crime. Yeah, QZ doesn't even have a plea deal. And they still put him in jail over the weekend for revenge, I assume.
I've got these 2, 3, 4, 5, 6 kind of stacks of the correspondence between the state and various attorneys for co-defendants who've pled. And I really hate to do this to you. And some of them are really thin, so it's easy enough for me to just sort through it, but some of them are fairly thick, 2/3 of an inch.
I know, and that was the
And
thing down.
they are in, I don't know, because I've only just.
Remember, folks, this was what the state was supposed to hand over last week. They didn't. Now they claimed, oh, we had everything prepared. We just wanted to do this. Oh, you lying sack of shits. And now they are handing over. I assume that they are adding in things just because they could. And this was what the judge was supposed to do during lunch. And not until during or even after lunch, they actually provided this.
Now kind of flipped through, but they don't seem to be in any kind of like chronological order. But it may be that, you know, something is like a string that started in 2022 and goes all the way through to 2024. I don't know, maybe. But they're all just sort of bound together as one. And it would be so much more helpful if I knew where one email stopped and the next one started.
Okay.
So can I give these back to you
Yes.
to sort of put in just a little
Oh.
bit more followable format?
Oh, this is tactics from the prosecution. This is tactics. I mean, but then again, it's not hard to know where. Well, it shouldn't be hard because if you read an email, okay, it usually starts with hello and ends with their signature or a statement and blah 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 in the end. And apparently the prosecution decided to make the judge's day a living hell today.
And then y'all can give them back to me in the morning. Okay, and if you can start with whomever the attorney for Mr. Zachary is, since he may be the first person.
He's not, he
He
wasn't.
won't be.
He wasn't, he's not one of these people. He did not
Oh.
plea. He was not
Okay.
a defendant on this
Okay.
indictment.
All right, great. Then we won't have to worry about that.
Can I ask you a quick question about that?
Yes.
I may have misunderstood Miss Love earlier, but when she was talking about giving you these communications,
Mhm.
I thought I heard her drop in a clause that said, except for the plea negotiations.
I don't remember.
Did
her
you say that,
saying
or did I mishear you?
Yeah,
Okay, great, thank you.
yeah. Mr. Short, you had some sort of an evidentiary issue to raise.
Yes, Your Honor. I believe it's 464 Yankee. It's the historical cell calls of Demise McMullen. The witness identified it as a business record. Of course, we just saw it on this, we saw a CD. But it was briefly displayed to the point that I saw it. It has added columns that 464 Yankee, as it is right now, has added columns that are not in the format that they would have been received from Verizon. That one added column is.
Hang on, can you pull it up so I can look at what he's talking about? Go ahead.
And so typically, I do the same thing when I get cell phone records. I add columns to identify the people that I believe are associated with certain phones. And it looks like that's what someone that was not an employee of Sprint did here. And
so I see on the screen right now, columns A through I.
so I'm referring to D, and there's one over on the far right that might be like J or K.
Yeah. What Mr. Short is describing here is when you get these records, I sadly handle similar records. In order to summarize what I've seen in, for instance, columns A to C, then I add a column. Okay, this is the person. This is the information. Da 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 da. Now this is my own add-ons, and then a few columns later I add one more. Da 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 da. And I do that so it's understandable to me, but I cannot present my columns as custodian evidence, because that means the evidence provided has been changed. I must have the original, then I make a copy, which is my worksheet. So the prosecution here is trying to get their worksheet in as evidence with their own markings. And no, absolutely not, because that is not the original. That is not what's been handed over to the prosecution. Jesus Christ. And this is how sneaky the prosecution is.
Okay.
Okay.
M. So those are things that someone, as part of the investigative team, added those.
Let me ask.
So we actually did, and we are deleting those columns and adding them to and making sure that the correct column is there. I don't think
No, you have one original, then you take a copy as a work product, but you cannot make changes in the fucking evidence. For fuck's sake. This is tampering with evidence, Miss Hilton, when you make changes in the things you are oh God, no. This is so improper. No Curacao. Hey, interesting how they knew, but didn't want to introduce the correct one until they were found out. And they do it all the damn time. They wanted to enter a tampered piece of evidence into record, have it testified about. This is highly improper. This is criminal behavior, folks. Criminal. Jesus Christ.
myself or the Verizon custodian, because she observed these records or she reviewed them. She must not have caught that because we sent these to her so she can look through all of the documents. And so once we published this is when we noticed that we immediately put it down. And so all the other columns are the same as the historical cell site explanation.
Other
form,
than D and M?
Other than D and M, so we.
And so
had-
y'all are gonna withdraw 464Y and put in a substitute 464Y that,
Judge, for fuck's sake. Oh, I'm so demonetized. Why are you allowing the prosecution to even attempt to enter a tampered evidence? Don't, jeez, no. Oh, for frick out loud, you absolute. This is so unethical, folks. I cannot emphasize enough. As Samantha Jones says, no, photocam, yeah. But this is equal as having a picture, photoshopping in things that you interpret, and then try to present that, a photoshopped picture, as evidence. This is equal to that. It is that bad. And why aren't the judge doing anything? The entirety of that piece of evidence, whatever Verizon testified to, gone, out. Because the state tampered with the evidence.
does not include, or that shifts everything over 2 columns, I guess?
Yeah, so
or what?
464 Yankee is what we thought was the entire Verizon records as returned. So we're going to take out this one document and replace it with the right. This one.
So it's
titled
only this one McMullen.
yes.
Okay. Okay,
How
let's
do you-
try to be a little bit more careful, please.
Yes, and we will, Your Honor. Yeah.
How? Be more careful. Your spineless. Jesus. This is evidence tampering, Your Honor. This is evidence tampering. And be more careful going forward. How do you know they haven't done the same pile of this before? They just got discovered now. This should be an evidentiary hearing on itself. I cannot emphasize enough. This is beyond improper. This is criminal behavior. Doing this, trying to enter a tampered evidence into record. They are 3 prosecutors on that one. They have another 2 prosecutors. They should. This is evidence tampering. Clearly.
Anything else on that?
But
I mean, it's not that this is correct. We do expect the evidence will come out that these are Demise McMullen
Okay.
records, but we will make sure it is the right records.
Okay. And actually, one thing you just said reminded me of something.
why? I don't know why the defense doesn't make a bigger deal out of this. But maybe they are so used to this happening in Fulton County that they stopped reacting to it.
And that I wanted to bring up, you had said you sent them to her to review, and that's great. But that just reminded me, we've had 2 sort of, I don't know, crime scene-ish type witnesses on the stand today. One of whom reviewed 60 pictures on the stand, and one of whom reviewed 127 pictures on the stand. And they actually did that pretty fast. But is there, I mean, would anybody have an objection to when we're talking about, the actual people that took the photos, who are also kind of professional at doing these kind of jobs? I don't mean like a victim of a crime and this is her house. I don't mean like that, but like, the reporting officer to the scene. Would y'all have any objection, and this goes for everybody in the event that the defense ends up calling witnesses as well, to just being able to have that witness when they're waiting outside, go ahead and review them just to see, you know, hey, are you familiar with these? So that when they're on the stand, you can say, you know, you review them outside at you know, everybody agrees and all of that's fine, but that might save 10 minutes, 5 minutes here and there.
So, Your Honor, actually, the witnesses that had reviewed them, they, in one instance, at least the 128 photos, they had actually initialed every one of, like, they had reviewed.
Right,
all
but
of
when
them.
they get handed to them by an attorney and say, can you, and I know that's like what, you know, the process is, but it is equally okay to say, you just review, you know, you just now reviewed these outside, you know, are you familiar with them?
We can
or
do that.
whatever. And I mean, obviously, if you give them to them and say review, they're going to do it again. But
Oh, I
anybody
got
have
you.
a problem with us, you know, maybe like cutting out a minute or two here or there just by doing it that way? Everybody's good with that? All right, let's, you know, from now on, and maybe it'll save us a day or something. I don't know. Okay. All right, I have listened to the entirety of the recorded conversation between the investigator and Ms. B. And she essentially, I guess I see where she got the idea that I, as the judge, had been the one that said she had to testify. Not really, but I get where she got it, because at some point the investigator says, so we'll let the judge know, or Miss Hilton will let the judge know that you don't want to appear. And it was in the context of appearing on camera. But I mean, I guess she took from that, oh man, they still gave me a subpoena. So the judge said I have to appear, when that's not in fact what happened. But there wasn't anything nefarious going on. It was just a kind of a misunderstanding, I guess, on her part. And the only other thing, just for, you know, I mean, she is reiterating very strongly.
An investigator told the judge that she had to testify. An investigator told a witness the judge said she had to. That whoever that investigator is should be jobless and homeless. And I assume it's one of the prosecution's investigators. Jobless and homeless, out on the streets. Judge, do something. You can't have the prosecution's investigators going around lying to people. You can't. You tampering with evidence, investigators lying. I mean, and this has been happening throughout this trial with these freaking investigators. One who sexually harassed a witness, and as you might not know that, but what was her name? I don't remember her name at the moment. She was jailed because the investigators told, and the prosecution told the judge, she said out loud she's not going to testify. And she never did. They jailed her anyway. This is so hopelessly unethical. Bar cards should be revoked immediately for this absolute clusterfuck.
Everything that she put in the email that y'all all have access to about that she wants everybody, prosecution and defense, to know that she does not consider herself a witness. I'm sorry, a victim. She does not consider herself a victim. She doesn't look at herself that way. It's a surprise to her that anybody thinks she's a victim, given that this was sort of collateral damage to her apartment. Her apartment wasn't targeted. If she is called to testify, I think she's very much going to make that clear from the stand. One question I have is, given that we already have the testimony from, I think it was Officer Hill, is there anything additional that this witness would be able to present to the jury that would not be cumulative of the officer's testimony?
Your Honor, I think that, and I'll have to confirm reading her, what she did tell them, but I think that she, one second, let me confirm something. Real quick.
Okay.
If it is this hard for you to find a reason, then no. This poor woman does not have to uproot her life just because you are bad at your job, Miss Love.
Thank you.
We can, Your Honor, we can evaluate that.
Okay.
And
All right. Thank you. I appreciate that.
This is Judge speak for.
All right. I'm trying to think
Don't
if
be
there
an
was
ass.
anything else that I wanted to tell y'all, but is there anything else that y'all want to tell me or that we can deal with right now?
I think I think I briefly mentioned it while we were there at the bench, and the court said that that was something we didn't necessarily need to take up, but there may be, given certain evidentiary matters that we could not broach with certain witnesses, there may be
Okay.
a need to bring in.
Oh, yes, right. Thank you. Okay, so yes, there were, which officer was it? The officer that reported to
Miss to Miss
not
Bees,
Bell?
no, Miss,
Okay.
it was Officer Hill.
Was it Officer Hill? I don't think so. I think it was before that. Oh, yes, yes, yes. Who the neighbor was, who was in the neighboring house or apartment. And of course, there were hearsay objections, and I mean, it's a valid hearsay objection, and that's why it was sustained. But out of one side of defense mouths is a lot of, can we move this trial along? The state's taken too much time. Why does the state want to present all of these witnesses? And then the state had apparently cut a witness or two, hoping to just have this officer testify to who lived next door.
Yeah. Not the defense problem that the state is bad at their job. Not their problem. You made a ruling. The state made a bad call. Live with it.
And now the state needs to bring in one or two or three more people. And it's fine. It's a valid hearsay objection. And maybe, I don't know whether the state had talked to the defense about, hey, we're trying to cut down on, the time that this trial's taken. We're thinking about having the officer testify to who lived next door. Would y'all have an objection to that? Are you going to make us do all of that? And then we'd know beforehand. So I don't know if that happened or not.
We had not done that thing
Okay.
right there. We had provided a list that had people that had other people on there.
Yeah.
And so we can make it plainer.
Okay.
For instance,
This is on the state completely screwing it up. This has nothing to do with the defense asking the judge to tell the prosecution to speed things up. If you're this bad at your job, it should be reflected in the trial. If they can't get a certain piece of evidence in, too bad, too sad, move along.
with I think that we had mentioned a few days or weeks ago regarding some of the maybe some crime scene technicians that we were going to eliminate and have some officers testify about, but we need to bring in, because if, there are certain objections, there are just that are
Okay.
sustained.
So, yeah, maybe let's short circuit some of this in either talk in person or over email or with a representative or something. When you've got an idea like that, like, okay, I can eliminate 3 witnesses if there's not a hearsay objection to XYZ. And then defense attorneys, y'all can let the state know what your position is. And if your position is, we don't care about saving 5 days of testimony, we're going to make the objection, that's fine. Y'all can.
Why is this on the defense, Judge Whitaker? Why do you put this on the defense? Why? They have no responsibilities in helping the state build their case. None whatsoever.
Do that, but then they'll know ahead of time and they won't maybe even attempt to get that in the other way. So I don't know, thank you for bringing that to everybody's attention. And yeah, just in future, if there's going to be a potential shortcut, I appreciate you trying to think about it. Just let them know beforehand, and then they can let you know, is that going to be one they're okay with or not? Okay.
Yes, Your Honor, thank you.
And we had the outstanding issue about AS not wanting to be videoed. I don't know if you want to take that up now or if the state's prepared now or
I
later.
don't know. I think, were y'all going to get further information and get back to me?
Yes, we were.
And you're not ready on
No,
that
we-
yet?
no, we-
Okay, I know it's only been a couple of hours.
Right,
Okay, and do we know when they're going to be, this week, a month from now?
I'm checking because my partner, not the
Somewhere in
court.
between?
But no, as the matters that we were bringing up to the court earlier regarding longer people have shifted our.
Right, because I don't know who was up here, but y'all all heard there was an expected witness.
Folks, Mr. Jingles is here. Our supreme leader of Mr. Jingles Viking Thugs is here, blessing us with his presence. Us with his presence. Hello, Mr. Jingles. Hello. Hello. Have you been a good kid in catching rodents? Not letting them inside and catch them inside this time? That would be really, really nice of you. The last one took me 3 days to find. That was not a pleasant smell. Oh! Catnut Williams gifted 10 memberships. And I assume that Cat is done for today and sent everybody over, because I had a clear spike in viewers. Yay! Oh, hello, Cat's viewers. Cat raid. Did you hear that, Mr. Jingles? We have a cat raid. Let's get a bit closer here. Yeah, if you go back half an hour, you will have was it half an hour? Maybe half an hour. You will have one of my epic rants. One of my rants. When the prosecution actually tried to enter tampered evidence into record. Thank God Mr. Shaw discovered it. But that kind of, as I said, hello, Mr. Jingles, hello. As I said back then, half an hour ago, them trying to enter the Verizon records with their own notes is equal, according to me, is equal to photoshopping a picture with what you believe is in the picture, should be in the picture. This is so unethical, and the judge did nothing. Just told him, oh, be more careful. If the defense hadn't noticed, that would have been entered into evidence. Hello, Mr. Jingles. Hello. And I'm beyond furious, both at the prosecution trying to do this again, and the judge doing nothing about it. Yeah, like a cat that finds a box to sit in, the state will inject testimony. Yeah, it's infuriating. Yeah, Miss Bennett, thank you. Brenda is, we were talking about how they jail people, how they lie. And now apparently an investigator told a witness that the judge told her, you have to testify. Not true. And this again is the unethical things this prosecution does with the investigators. That investigator, what's his face, who sexually harassed Miss Bennett. This is infuriating. This is extremely infuriating. But we do have a bit more to get through. Thank you all for being here. And let's see. I just have to. Ow! Can you boop me without claws, Mr. Jingles? That would be so nice of you. That bring. Whoa! And thanks to Catnot Williams, that brings us. Ow! To 10 new members today. 10 new members. Hey! Thank you. Thank you, Kat.
Was it Turner? Who was it that you said hurt their back?
There were two, and Detective Thorpe hurt his back.
Thorpe.
And obviously the other witness that ended up at Grady this morning.
Right. Yeah. So, right. So there has been some, as of, I guess, today, information learned by the state that's going to require some shifting around of witnesses. So do you still expect AS to potentially testify this week, or will they get moved?
They may get moved.
Okay.
We also want, as we're trying to find out certain statuses.
Okay. So I guess maybe just let us know first thing in the morning if you have further information or not.
Yes, we can do that.
All right. And with regard to all of the things that were due from everybody, including Ms. Abbasi was going to give me something. Are those on their way to me?
So yeah, we have the brief. We have to file the brief,
Okay.
but we have the brief written. Yes.
Okay. Okay.
And let's see what else.
Laura.
And I think that we are. Let's see what else.
Hey, Kat. Thugger Daily has dropped a few new motions and reply to motions. Get in here and we can go through it. And you can restream to your viewers about it. So, Kat, get in here and we will go through it as soon as we have half an hour left. And then I will go through the new motions that dropped right now by by Thugger Daily. Thank you, Mixed Chick, for getting that to my attention. Thank you so much. Yes, I will go through them.
Everything. We're going to work on these.
Speeding up to 1.25.
We are still cutting out the court asked us to see if we could pare down the list of co-conspirator statements that we had given, and we were still
Still working
paring
on
that
that?
down.
Okay. So I guess as you know of, if you've been through 3 pages and you at least know that, like what is in and what's out for those, just kind of pass it along to the defense, as y'all know, so that they can start to focus on what objections, if any, they want to make to the stuff you do want in.
Yes, Your Honor.
Okay.
Yeah, these damn documents, she was told to be ready weeks ago, and she's not, Ms. Love. And,
Your Honor,
Yes.
because of that need to rearrange witnesses this week, does the state anticipate any witnesses this week that were not on the witness list circulated last Friday?
Your Honor, in light of the timing of all of this, of course, we've all been in the same place, but that is possible. So first of all, we need to find out that information about the status of the longest witness that we had, because we want that person up as quickly as we can get them. So until we get that information, we cannot commit to whether that's going to change things and put people in, but it is likely that we will have to bring in people that we were not going to bring in for this week.
Okay.
Because-
So yeah, it sounds like it's just as likely as not that it'll be a different list of witnesses. Can you get that together tonight and get it to the defense?
Yes,
I
and
assume- do you know which kind of set of acts you're going to go to?
they're all dealing with the set of retaliatory shootings that occurred after January 10th. And it's possible that another co-defendant that entered a plea, after I speak with this person's attorney, I can confirm that, but it's possible that one of those people will be testifying. But
Can you let them know by like 8 o'clock tonight?
yes, as
If
long as
it's
we
not
can,
the people you put on before, like who you think it is going to be?
yes, and yes, we need to
Okay.
find out. We really need to find out one status of one person.
Okay. Well, and I guess if you don't know for sure what the
how about that? They have gone through so many witnesses the past month with evidence, with this, with that. And all of a sudden, well, we are going to try to add on witnesses we haven't gone through yet. This is
status of that witness
We'll
is,
assume.
just go ahead and, give them the fallback set of witnesses.
We can do that.
Appreciate that. Okay.
Yeah, this is ambush. Complete ambush by the state.
So are there
Because
other
they are
matters that
bad
we
at
can
their job.
deal with?
If we could be allowed to, as soon as the court permits, we want to start alerting certain people if
Okay.
there is the need to,
All
and to find out those statuses.
All right, well, the answer can be no, but you can also send one of the 6 people that you have in court right now off to do that while you stay around and deal with potential evidentiary issues. Right? Yes.
Give it, I'm probably the one that's going to be pointing
Okay,
out the ones that need to be.
Then you go and let somebody else deal with evidentiary issues. There may not be any. I don't know. Why don't we just take the 2 more minutes and find out if there's an answer to the question? Are we ready to deal with any other non-jury matters right now? I really need y'all to get that way soon, though, because we keep having these unexpected non-jury.
Because of the prosecution, Your Honor. Don't look at the defense for this. This is all because of the prosecution. Stop looking at the defense as if they had anything to do with it. hit the thumbs up if you wouldn't mind. Would greatly appreciate it.
3 hours, so let's get ready fairly quickly to deal with some evidentiary issues. Okay?
I'll say this, and I believe the court was copied on it. Mr. Steele filed after their review of the evidence item. So we just need the opportunity to look through that
Yes.
filing and we can work through that.
Okay.
Okay.
You added more? Okay, great. All right. Okay, yeah, anything else right now?
Just I found that last witness interesting, so I'm getting cases for you, and I put it in writing just so everyone's alert.
Okay.
And I put it from me, but I did discuss with everyone on the representing people here, representing the accused here.
Right.
The last witness said that column in 1 TT, she could not verify its accuracy, and she's a records custodian, which has to verify the accuracy that it comes in the normal course of business, and it is how they handle it, and it's accurate. And I have a couple of cases, but I'm looking for more. But I'm going to be objecting to that column. I just want to give you, if you want to take that up now, but I am looking for more cases, but that will be an objection. And that was preserved, I know, by we went to the bench and we had specifics on the text messages, certain words, certain messages were not relevant, but I wanted to make it encompass that entire column.
Okay, so the objection at the bench was that in terms of the content, we hadn't hashed out
Right.
whether.
Objection of the what? Objection of the what?
Make it encompass that entire column.
Okay, so the objection at the bench was that in terms of the content, we hadn't hashed out
Right.
whether
Now I'm objecting.
whether everything was going to come in or not. And it sounded like that with regard to authentication, as long as she testified to authenticate everything, it
That's
would,
my
that objection that wasn't going to be made. And I've kind of already admitted it although I think all that's been displayed so far is maybe 1 page worth. Is
Yeah,
that right?
And you blacked out. The Honorable Court ordered it blacked out. So there's no, I'm not trying to go backwards. I'm just
Okay.
saying in the future, we would like to exclude based upon that testimony, the text messages.
All right. And do y'all want to respond right now or at all, or?
Yes, Your Honor.
Okay.
We believe that the testimony of the custodian was she cannot verify what actually gets transmitted into the document, but the document as it is what Verizon gets, what Verizon produces, and that none of the people at Verizon manipulate what is in that content column, but it's solely because of transmission. She even gave the explanation. An emoji might not come through because of however the language changes. When I say the language, I mean like the technical language changes, but whatever is in the record is what has been transmitted and produced into the record. And so
Is what Verizon has.
is what Verizon has, and Verizon produces what it has.
Yeah. So, I mean, I think to that extent, it is authenticated as the records Verizon has. And with the sort of caveat that what is shown in the content column may not be precisely what it was my understanding, she was saying it might not be precisely what the ultimate recipient gets because it may not pick up something like a symbol or an emoji.
Yes, Your Honor. Yes, Your Honor.
So I don't think that column is not properly authenticated. I think it is. It's just that you all will be able to make whatever argument you make about whether they should believe anything about what is said for the content of that. It is what Verizon gets from the switch, whatever the switch is.
She would, and obviously Miss Winfrey would be the best person, but the way I have it is Miss Hilton asked Miss Daniels, the witness, and the content column talking about what we're talking about. Does it have the content as it is texted on the phone or on the device? And Miss Daniels said, no. That's information that we would not be able to confirm or deny. There could be things that are not transferred through the network, or there could be symbols that don't transfer over. So I can't say one way or another if it's directly like what it was texted. That was
Right.
not direct.
And then following up, we got further detail that it sounded like it was things like symbols and emojis, but that what is shown on there is what Verizon, that comes from the switch/network essentially. So.
Okay, I'm just, I just want my record, I guess, to be accurate, but I asked on cross-examination, I said, can you do me a favor? What happens if I were to send you a text message and I asked, how are you? On the records, it may not come out like that. Is that what you're telling the jury? And her answer is, that is a possibility.
Yes.
That has nothing to do with an emoji. That's the words.
No, I heard that too.
She said there could be a lot of factors, but I wouldn't have the factors to provide to you. I'm not able to provide that. I don't have that information to tell you is what she said.
Okay.
So I would like you not to admit that column.
Okay, well, it's somewhat problematic that you're only making the authentication objection now after the witness is gone.
They didn't discover this until after, because Mr. Shard, for frick's sake, Your Honor, you are allowing so much leeway to the prosecution, who is violating your direct orders. But this, seriously?
I'm not trying to, I thought we made it.
You made a relevance, well, not you, but you, the defense team, made not even a relevance objection, but made an objection to essentially the kind of thing I understood it to be, not as to authentication of anything, but as to should something nonetheless be excluded content-wise because of some other objection, like we've been hashing through with other people's phone calls and interviews and all of those kind of things that are otherwise objectionable. And I'm sorry, that was the way I understood. I think I even said so not authentication. This is just going to be authentication here.
Well, I don't believe it, that witness.
I mean, apparently you didn't mean that, but I didn't.
Well, I
know
don't,
that.
no, I did not, I wanted to hear from the witness. That's why we would not stipulate. And the witness, I don't believe, laid a proper foundation before this honorable court for text message content. And I don't believe it's waived.
Your Honor, I believe that argument would go to weight and admissibility. She said that these are the records that Verizon gets, these are the records that Verizon produced pursuant to the subpoena that she received, and that this is the information that was given from Verizon. Now, whether or not defense counsel wants to challenge the content inside of it based upon what she said, they can, but the records themselves is what came from Verizon. I think she was clear in. I'm saying that I can't tell you for a fact that this is what was put into the phone, but this is what was transmitted from the switch, and this is what was produced. And again, no one has changed what was in the content column, but this is what is produced directly from the records.
Well, except that you added things in your own column and tried to enter it. And now you're whining?
And it was probably authenticated because there was no authentication objection at the time in which the records were tendered and admitted. And these records have been provided to defense counsel, I believe, since 2022. So that column is there. So even when she began talking about it again, doesn't change the fact that the records themselves are authenticated.
No.
And I really do think that if there were,
even if they were handed the correct ones, you presented tampered ones.
was going to be an authentication objection to that column, even, that you could easily have alerted the court to the fact. And I know you were examining her about, well, is the content going to be exactly this, or, is this something that if displayed to the jury and it says, how are you? It may or may not have actually said, how are you? But with regard to it being the record of Verizon, you should have said, I've got an authentication objection to this based on what she said.
I'll look at a waiver issue, but
Okay.
I don't believe, they put up the witness, it's their burden, and the witness did not come through on that column, in my opinion. And we voiced an objection.
That's the part I guess I'm having a problem with, is the we voiced an objection part, because you did not say that you had an authentication objection when we were up here at the bench.
Okay, so whatever was said at the bench is said at the bench, and then we blacked out, we mean the court blacked out. And now I don't believe that there's any reason to say that it's waived, because it was blacked out, not discussed, and the witness did not lay the foundation, in my opinion. And
they may not be able to. I'm just saying, the time to make the objection is when we still have the witness available.
well, then, I mean, the witness was examined, she said on direct, then on cross, and then on redirect. And I don't believe that portion, when a records custodian comes in and they say, I cannot verify the record, this is what I have, but I don't verify it, then they have failed.
Well, she's verifying that this is the official record of Verizon.
But I
She's
can't
just
verify
saying,
the content.
I guess we can't verify that the content is exactly, that the content, but I mean, this is what she could have clarified if we had known that this was an objection.
Yeah, I believe she did. I think she did clarify, because when the question came on cross, what she said is this is the content that is given from the record, from the switch. So this is.
We know what that means. She said network at some point, but I mean, I don't know.
You're right. I can, if we
I-
need additional clarification, I can see if she's available to return. But again, she confirmed that the records that are entered are the records that are produced. That is what has to be authenticated. The content inside of it, she explained, as a Verizon custodian, I cannot say this is what was texted in the phone. However, this is the documentation pursuant to what has been transmitted that comes in. She gave further explanation to explain, I'm talking about emojis might be missing, but I also asked her, does anyone at Verizon change what is in the content itself? And she said no,
Right.
because that is the record as produced. So she authenticated the record. If
Right.
there's a challenge to the content,
I mean, I guess it honestly is more like, Mr. Steele hasn't referred to it in this way, but if there is a column that, and if it is all that could possibly be missing is an emoji or a symbol, that's one thing. But that's, I mean, part of her testimony suggests that. Part of her testimony suggests it may be more from the, if I text you, how are you today? And you can't say whether the record's going to reflect that or not, then maybe it's something more than the emoji. And this is something that could have been cleared up potentially if we still had the witness. But if it is, if the contents of the content column can in no way be relied upon to be even close to what actually got texted, and I'm not saying that that is the case, but I'm saying I don't think it's 100% clear about that. Then it's essentially would be like a relevance objection to that column, regardless of whether it is the document, the official document from Verizon. So while Mr. Steele has said it's an authentication objection, I mean, is that essentially what you're saying is that if we don't know whether anything about that content is accurate, then why should that ever go before the jury?
Of course, that's what I'm saying.
Okay.
But I think that that can be an argument. And when the contents come in, there will be corroborating evidence around the relevant content. I think that that's something that can be addressed on a text message by text message basis once we get to that portion of the identified text messages in the relevant portion of time.
Well,
and I mean, if we need to recall the Verizon wireless custodian, we can do that. I can see if she's available tomorrow morning.
I mean, it's ultimately up to y'all, but you hear the arguments being made. Okay. All right. Anything else today? No. All right. Okay. So we're gonna, I guess, adjourn court a little bit early for today, but please, just like Friday, please continue to work on this case together and separately, because there is clearly so much still that needs to, that y'all need to get together on and address. And
Why, Judge Whitaker? The state has had over 2 years to get their case together. Why do you put it on the defense to help them? And as Linda says here, the custodian can't answer this like an expert. She cannot. Oh, hello, Mr. Jingles. And Judge Whitaker is all about timing. And she sees this all the time in court, that the reason of all these untimely things is because the state is not prepared. Remember, the state said they were ready for trial in December of 2022. We are almost 2 years later, and they are clearly not even prepared for trial.
let me know about, so that we can sort out whatever issues remain and not have to Only do it on the fly. Okay. All right. So I'm thinking 8:45 tomorrow for all of us. All right, I'll see y'all then.
And did the court give you till in the morning that you wanted these things?
You could just give those to me first thing in the morning,
Okay.
and by first thing in the morning, I mean 8:45.
As if Miss Love cares, because she's been going. She has been getting away with this for 2 years by not presenting anything. All right. Let's see here if I can get this up and running with. Okay, next part of this stream is we are going to talk about the motions that has been presented, and thanks to Thugger Daily, we can read. We can read. Let me just put. I will put this up here and that there, and I will do a swoop so it will be easier to me to find. So here is the swoop. The Norwegian fire-farting dragon swoop. All right. Let's get this on the road. Okay. Motions. Motions time. 10 pages. Yeah, that's good. State of Georgia v. Jeffrey Williams et al. Joint motion to exclude evidence. Come now, Mr. Jeffrey Williams et al. Herein after the defense. By and through their undersigned counsel, and hereby file this joint motion to exclude evidence in the above reference case. In support of this motion, the defense shows as follows. The defense respectfully requests this honorable court to exclude photographs in Dropbox 59 Antonio Sumlin for the reasons set below. Photo 1. Photographs 4 through 9 of 36. These images, based upon the fact that the unrelated firearm should not come into evidence pursuant to these case law or these rules, OCGA. Yeah, if guns aren't related to a specific crime, then they are only used as bad character evidence and should not be allowed. Number 2, photographs numbers 1, 2, and 3 show a red bandana and are cumulative, and hence only one photograph should be admitted if same passes OCGA these rules. And this is the footnote here. As ordered by this honorable court on Friday, September 13th, 2024, Friday, the defense is not targeting any body camera or recorded jail calls contained in this portion of the discovery that is being analyzed, as the prosecution was ordered to specify which part of each body camera and recorded jail calls the state wishes to introduce into evidence to present to the jury. Then the defense will voice objections, if any, to those segments. If this honorable court decides otherwise, please advise, and the defense will follow this honorable court's order instanter. Okay, number 3 here. Photographs 10 through 36 are purported to be Mr. Sumlin's body with artwork, and same are cumulative and hence prejudicial, if relevant at all. Thus, the defense asked the same to be limited, if any are admitted. Number 2, the defense objects to the following evidence related to Miss Latner's purported testimony being admitted at trial. 1. Miss Latner's March 13th, 2022, blah, 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 report and 911 call from Paula Tiffany LNU violates the confrontation clause, as well as hearsay, as the communication is not concerning an ongoing emergency. Yeah, this is a much later 911 call that may or may not be even related to this case. 2, March 14th, 2022, report ending in 1882, page 304, reads user Chris Butler as same is supposed to be images of a license plate reader and are not self-authenticated, and adds additional information that is used for prosecution and thus violates confrontation clause without a proper witness being able to cross-examined by the defense. Yeah. Images of a license plate reader is second-hand information, and they need somebody to testify about this in order to be able to cross-examine. It should not be just admitted as evidence. Number 3, March 17th, 2022, SOS Channel Pursuit. The defense objects to the admission of this file in its entirety, as same is cumulative as the officers involved in this incident will presumably testify at trial. In the alternative, if this audio file is admitted, the defense specifically object to the playing of this audio from start to 1.30 and 15:10, which deal with a different issue involving an animal and hence must be excluded pursuant to these rules. Moreover, the defense objects to references of a possible 69. I mean, it would be interesting to, I don't think they mean that kind of 69. At approximately 13:30 and 13:45, as same is a testimonial statement in violation of the confrontation clause. They cite case law. Additionally, at 11:30, there are 2 references to both subjects being quote-unquote armed and dangerous, and same must be excluded under OCGA, these rules. And it violates bad character evidence. Yep. At 12:22, there is a reference to one person throwing in a bag. And 12:45, there's a discussion about whether said bag was located. This is testimonial and violates the confrontation clause. At 13:05, there is a reference to Mr. Shannon Stillwell, which is testimonial and violates the confrontation clause. At 12 and thereafter, this audio must be excluded because of the quote-unquote ongoing emergency was over as law enforcement apprehended the suspects. Yeah, the state is trying to just admit this without anybody actually testifying to it. Act number 124 from Mr. Sumling, ending in C6D4, if admissible, needs to be redacted as same is redundant. The defense position is that this purported exhibit must be excluded under OCGA, these rules. I don't know what that is. Act number 124 from Mr. Sumlin. I assume this is an overt act of some sort, which some of these overt acts apparently consist of just a piece of evidence. Act 126 7AC and Act 126 627 for Mr. Sumlin are photographs purported to be shirtless images of Mr. Sumlin displaying tattoos, which is cumulative of previous photographs that the state wishes to admit into evidence at the trial of the case in violation of these rules. If this honorable court admits over objection, the defense asks for the statement, quote unquote, chasing that money, but my past chasing me, to be excluded from coming into evidence against the criminally accused on trial, as same does not further any supposed conspiracy. Okay, it's a song. Again. The defense respectfully requests any and all commentary be removed from act, blah, 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 blah. That, in my opinion, goes to the prosecution adding information in the evidence. Act 73E55 is cumulative to a video that the state is attempting to admit into evidence and supposed statements by Mr. Sumlin. On the bottom, do not further the conspiracy. Moreover, Act 73 RP replay is the video of Act 73E55 with audio, and hence Act 73E55 should not be admitted into evidence if Act 73 RP replay is admitted into evidence, as same is cumulative. Moreover, this purported exhibit is on a loop and should not be played more than once if admitted over objection. Also, the defense respectfully requests the removal of Mr. Sumlin's writing. Yep. Act 171. There are two short. Here comes my pronunciation again. There are two shots that appear to have been made by an unknown party, detailing supposed telephone calls and their duration, and unless the foundation can be shown that they're for the original records from which these summaries were made, the defense objects. If admitted over objection, this summary chart should not be permitted into jury deliberation rooms based upon the continuing witness rule, as well as not original evidence but is testimony. So summary, that is more or less like the, what do you call it? The what do you call it? Well, all the pictures that was excluded because it's summary. You need the actual evidence, not the summary. Summary evidence is just bad taste. The defense objects to the audio call located at this act, which contains Christian Eppinger and an unknown female. Under OCG blah blah blah, balancing test, waste of time, confusion of the issues, prejudice substantially outweighs any probative value. The defense objects to text regarding Lucci based on hearsay, relevance, and confusion of issues and cumulative. Okay. The defense objects to the audio file labeled October 17th, 2024 in folder 61. Freddie Whetstone. Interview with Freddie Whetstone, which consists of the content of Mr. Whetstone's interaction with law enforcement. Same must be excluded as it violates the confrontation clause and hearsay under this. Freddie Whetstone, I don't think he is on the witness list. So yeah, out with it. Out with it. No kerosene. Scrapbooking. Yeah. The defense objects to admission of report packet dated March 13th, 2022, written by Officer Steve Dadia, as same as confrontation clause violation, as well as hearsay, as it is not dealing with an ongoing emergency, but the report of a past crime. Okay. The defense objects to the August 16, 2022 report authored by Officer Ellis Anderson, as same is a confrontation clause violation, as well as hearsay, as is not an ongoing emergency, but report of a past crime. The defense objects to S. Davis crime scene report, as same is a confrontation clause violation and should not be introduced into evidence or shown to the jury without the witness present for cross-examination. Yeah, so S. Davis seems to be in CSI that is not on the witness list. The defense objects to the timestamps located on the still photographs from a video located in folder 65. Detective Grimsley's photos investigation concerning Mr. Drink's investigation absent a foundation being laid by the prosecution establishing that these are true and correct timestamps. Yeah, remember today when the prosecution argued that, do you really know that these pictures were taken on April 28th when Mr. Stilwell apparently didn't have dreadlocks? And then they questioned, and now, yeah, it's so hypocritical. The defense objects to cumulative photographs taken from the autopsy located in folder 73, Dr. Melissa Sims Stanley. The defense wishes to limit the number of autopsy photos. I believe they have gone through this, and the judge allowed 3 autopsy photos. The defense objects to photo number 26, a handgun presumably seized out of 2030 Waters Road by Officer Mercury on or about March 16th, 2022, located in Witness 74, folder March 16, 2022. incident photos as this firearm is not linked to any of the criminally accused on trial and has no nexus to any of the charged act, whether counts in the indictment or overt acts related to count one. Yeah, so the state only wants to look at this person. That person had a gun. Wherefore, the defense respectfully requests a hearing on this joint motion and at the conclusion of same as this honorable court to grant the above requested relief. All right. Well written. A bit technical, but very, very well written. All right. Next one. Hold on here while I go up to the next one. This one. Can you all see? Let's make it bigger. In the Superior Court of Fulton County, supplement to joint motion to exclude evidence. Okay, so this is a supplement to the prior one, I assume. Come now, Mr. Jeffrey Williams et al., herein after the defense, blah, 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 blah. The defense respectfully requests this honorable court to exclude photographs in Dropbox 59, Antonio Sunny, for the reasons set below. Photographs 4 through 9. Okay. Based upon the fact that the unrelated firearm should not come into evidence. Photographs number 1, 2, and 3 show a red bandana. Didn't we already read this? Oh, here's the supplement. On Monday, September 16th, today, the defense filed a joint motion to exclude evidence. This supplement is filed to add paragraphs 17 through 27. Okay. Let's find those 17 through 27. Here, okay. Here are the supplement. There are 2 audio files labeled this, locating in Viverito file under Act 171. Both are duplicates, and also duplicate of a call that is located in the Antonio Sunny folder. Yeah. Duplicate, I mean, yeah, that should be a no-brainer. The 2 search warrants itemized should not be displayed to the jury or come into evidence. Comprehensive Report 2022 is a confrontation clause issue and is objected to by the defense. Okay. The defense objects to a cash app document based upon foundation and relevance. Yeah, the state needs an actual person testifying. Without that, it should be going away. Mr. Eppinger's phone affidavit and search warrant should not be entered into evidence in any way or shown to the jury in any way. Mr. Eppinger is a witness. No, he's not even testifying, if I remember correctly. And I don't think Mr. Eppinger is charged. I don't remember. You all tell me. Number 22, the defense objects to the gang member profile of Mr. Sumlin as well as Mr. Eppinger as same is confrontation clause issue and should not come into evidence or refer to whatsoever. Gang member profile. So gang expert testifying about something previous gang expert has already testified to. 23, image 5167 appears to be irrelevant and no probative value. And dealing with Miss Brown is irrelevant to the case at bar, and the fact that Mr. Sumlin is followed by other people that may be involved in this case, that connection has already been proven, and hence same is repetitive and should not come in. Oh, Eppinger. Eppinger got severed. Okay. Records zip your file gives a file not found error, and thus the defense cannot voice an objection since we cannot open same. Yeah. Verizon exigent numbers ending in these 2 numbers should not be entered into evidence. Okay. 26. Investigator Viverito, Act 180, Ryan Rodelius contain conversation by a person similarly in a prison that would fall under hearsay without an exception, and it is hearsay and not non-hearsay, and same must be excluded. So it's a jail call, apparently. Investigator Viverito, Act 96, Jeffrey Williams discovery. 1. The defense respectfully requests the redaction of all commentary under the host, but include that it is posted on the shade room. Yeah, this is probably commentary from whatever, from Investigator Viverito. He can't add commentary and also present that commentary in the evidence as evidence. It needs to be removed. Okay, that was the supplement. What's next? Motion in limine number 56. Let's see here. Dun, dun, dun. Motion in limine. There, I need to have a quick drink here to moisten up my vocal cords or something. By the way, folks, have you hit that like button? Hit the thumbs up. You know I deserve it. You know I deserve it. Okay, motion in limine number 56 comes now. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby file this motion in limine number 56 to exclude any confrontation clause testimonial hearsay as well as statutory hearsay evidence concerning information obtained from the investigation by law enforcement on or about April 28, 2015, involving Miss Battle, and or any other supposed shootings for which the alleged victim or declarant are not called as a witness to testify at trial in the above reference case. In support of this motion, Mr. Williams shows as follows. Well, Mr. Williams is innocent of all charges in above referenced indictment. Based upon information and belief, the prosecution is not calling witnesses, supposed victims from alleged drive-by shootings that occurred on or about the early morning hours of April 28th, as well as other supposed drive-by shootings. Yeah, they have referenced these supposed drive-by shootings, but no victims, no witnesses. I mean, the gang experts have only talked about it. Mr. Williams again places in writing his objection to the prosecution attempted to elicit any testimonial statements and or hearsay statements from any law enforcement officers, whether responding on the scene or supposed gang expert or civilian witnesses that do not have any personal observations and personal information. Yeah, I would assume so. If they can't lie the foundation, then it shouldn't be testified about even by gang experts, in my opinion. And motion in limine number 57 here. Let me just pull that up. There it is. Make it bigger. Motion in limine number 57 comes now. Mr. Jeffrey Williams, blah, 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 blah. Shows as follows. Innocent of all charges. On Monday, September 16, 2024, the state called Verizon wireless records custodian as a witness at trial in the above referenced case. This witness could not verify the contents of the text messages contained in state's exhibit number 1TT, and thus Mr. Williams respectfully requests this portion of this exhibit to be excluded. Yeah, that was what we were just talking about before we went into this cluster F at the end of the trial. And I would assume that all of them has good foundation, all of these motions and motions in limine. But what will Judge Whittaker do? Help the prosecution, I assume. And definitely allow the supposed gang expert to testify about what they believe, which is insane. Judge Whittaker needs to hold the state accountable. She has to. She cannot keep punting it to the appeals court. She has to. She should. She probably won't, but she should start acting as a gatekeeper, not a friend of the prosecution. All right. Oh God, it's 11:30 p.m. where I am, and yeah, I need to go to bed because my alarm clock goes off in 5 hours. So, thank you all for showing up, folks. Thank you for allowing me to try to translate this trial for you. Thank you, guys. And remember, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. So that's it for me and Mr. Jingles for today. I will see you all tomorrow. I don't know when I can start stream, but hopefully you will show up. And so everybody, see you tomorrow. Okay. Bye-bye.
Gavel crack!